Okay, people. Okay, people, it's 3 o'clock, so we'll just start off this full council meeting. Welcome to the members of the public that are here today to talk at the public forum, and to my elected colleagues and staff. At this stage we have one on Zoom, which is Barry Stewart, and we have an apology from Trish Boyle as well.
She's here.
Oh, sorry, Trish, my mistake.
That's all right. That's nice.
Snuck in at the last one. So if somebody would just like to move those that we have a Zoom in. Leslie, thank you, and Darren, all those in favour?
Aye.
Carrie, any conflicts of interest as we go forward today? There being none, we come to the public forum. So Kylie, wherever you are, you're first up. General rule is you get about 10 minutes to speak. Whatever time you save during that period, we get to ask you some questions as well.
Yeah, thanks for the opportunity. I'd hoped to speak before the hearing, but unfortunately my submission was missed.
Yep.
I just really wanted you guys to reconsider before you approve the changes to the dangerous building policy that you're doing today, that more importance needs to be placed on expert advice. Currently, the changes you've made to this policy are so small that they're really not going to affect any major change. And after being through the policy and an ensuing hearing, it's just not fit for purpose. It really isn't. We had, I think it was 4 engineering reports on our building, and still council staff did not deem it dangerous. We had expert advice saying the building was unsafe and that people were at immediate risk, and we had nothing we could do. We worried whenever the wind blew, was something going to come down on State Highway 1. We had no power to do anything. We repeatedly, over 4 years, identified it to council through 2 hearings, and even when we did finally get it declared, the council staff didn't take any heed of the expert advice. We brought in landscape experts, heritage experts, resource management expert, and engineers. These people all submitted to our consent to demolish the building, and council staff, because they were not specifically told by way of something like one of these policies that they had to consider that expert advice, they chose to take it to a hearing. Because of that, we lost over half a year of our, half of our annual income for our organisation in going to a hearing that was not required. The council staff alone did not oppose our demolition, yet they took us to a hearing over conditions. Now, had a policy been stated quite clearly that, as my written report says, that expert advice should take precedence over council staff in lieu of any other expert advice to counter that, it should be the expert engineer who is openly, 4 of them, openly declaring the building dangerous under the Building Act, and even outlined it back in 2018, outlined what legislation could deem it as dangerous. They were still ignored. Anyway, 4 years and 11 months later, our building was declared dangerous. We spent tens of thousands of dollars on experts that council staff just ignored. It was a whole exercise in futility. And if you guys approve the one that's here in front of you today, I fear that it'll just continue the same way. And it was, I have to say, one of the most infuriating experiences of my life. There was just no sense to the whole process. So at our hearing, we had 4 experts sitting facing 3 council staff who offered no expert opinion. They did not have any qualifications to go up against our engineers and heritage experts, yet they contested our demolition, they didn't contest the demolition, only on the conditions of it. Now, all of that would have just been nipped in the bud if they had been told quite clearly, this is not your decision, this is the law's, and the law clearly declared our building is dangerous, but your policy didn't tell the staff that. So, as I quoted out one of our engineers in there, that in my submission, that he clearly stated in his report in 2018 that under the Act, staff are required to take expert advice, and they weren't. And that's my submission, so I'm happy to take any questions though.
A reflection from me, I sat through the hearing, so I can empathise with some of the things that you were saying.
Sorry, I can't quite
I
hear
can
you.
empathise with some of the things that you're saying. I sat through the hearing as well. I'll give you an undertaking that later on today I'll raise those issues as we consider the policy going forward. Because when you say, I guess there's two things from me, just as a lay person. One is that it's a little bit like lawyers, and Shelley, don't take this the wrong way, but lawyers have expertise in certain areas, as do engineers. So I guess as a regulatory authority, that you've got to make sure you're getting the right advice. To the fact that it comes from an engineer doesn't necessarily make it the right advice. But then I guess you've got to counter that by saying that when you do get advice, you've got to, if you don't take somebody else's advice, you've got to get it yourself.
Well, I think that calls into question the integrity of the experts and the professionals involved. I mean, when you get an engineer's advice, it's written based on engineering. So, and
yeah, but engineering is a very wide spectrum, just as the laws are very wide.
there's pretty much only one school in this country teaching it, though.
Yeah. Okay.
You know.
But I'll raise that later on today when we consider the policy. Any questions, councillors? Yes, Darren.
So specifically, what suggestion do you have, Kylie, that should be changed in the policy? And it can't be just, well, you need to make it so that this can't happen again, because sometimes applications are what lets an application down. And there are also waiting procedures that that hearings have to apply to expert witnesses. So what wording in the policy needs to change?
I put that in here. In my thing, I put in there that that something along the lines of, where is it? That could say something along the lines of that in lieu of, oh, here we go, I can't find it now, just a minute. Yeah, there we go. That could be something along the lines of, in lieu of expert advice, the following things could be considered, and that goes on to list what you've already got in the policy, or in addition to expert advice, the following should be considered. At the moment, you've got all of those reasons, which might be public health and all that, but I just think that the importance of expert advice when offered, and while I understand there are some requirements in hearings, if it gets to hearings, in our circumstance, it didn't need to go to a hearing.
There's no difference.
Sorry?
There's no difference. Expert submitters are expert submitters, whether it's just in the
yeah,
application or...
But what I'm saying is we didn't need to go to a hearing. That was staff contesting the conditions. But that's another issue. On the dangerous policy one, I just think that, I mean, because if it had been on the policy, when the staff got that, our one, they would have looked at it and said, okay, as I said 4 years ago, said, hey, the building is declared dangerous, and unless they can counter our engineer and his opinion, his professional opinion of it being dangerous, I wonder why they get to say, no, it's not been dangerous. As I said, in our circumstance, they used it comparing it with Google Earth images, and that's just scary that that was done in the first instance. But it just needs to be that why does this council staff member's view override expert advice? And without that firmly written in the policy, I think that's of grave concern.
So just to clarify then, expert advice trumps everything else?
It trumps staff opinion if they don't have comparable expertise.
Isn't that conjecture though? Because if you're stating that staff are putting opinion, do they not have qualifications that might look at
If they've got, hey, if one of your staff is sitting there with comparable engineering expertise, then that's comparable expertise.
No, my question is really, does one expert erase everything else? I mean, all you need is one expert.
No, I think if there's expert advice, it needs to be factored in far more strongly, or it should have to be counted, not just by staff opinion, but by equally equivalent expert.
Yeah. It's a bit risky calling it staff opinion, to be fair.
Well, if you're not an engineer and you're offering views on engineering to counter an engineer, surely you have to have equal qualifications.
You can say
Yeah.
that if you want. I'm not. No, that's fine. I'm not sure how we weigh that in, because it's about how much weight you apply to an expert witness once you get into a hearing
And
process
yeah.
or consideration of an application.
No, I do understand that it would be tricky, but I know, as I said, from our personal experience, 4 engineers. And, you know, it wasn't till we finally said, will you listen, if we employed the same engineer you guys use, and said, if we use him, will you listen to him? He came back with the exact same response as all the other engineers. Okay. So in light of that sort of thing, that will continue unless it is outlined that some more importance needs to be placed on for the professionals. And we're required to offer them.
Thank you.
Any other questions, councillors? No, at all? No, thank you, Kylie. Shelley, wherever you are. So Shelley, we normally have 10 minutes, but I'll give you a little bit of time concession, given that there's a bit of emotion around this.
Thank you.
And that we've only just got your paper, so I guess it's reasonable to assume that we haven't read that. So you might want to cast your eyes over that as you present.
Absolutely, and thank you for giving us the opportunity to present today. I wanted to give you in essence, what the representatives wanted to cover.
Sure.
Because I'm certainly not going to be able to get through that. Telling a lawyer they've got 10 minutes is a bit of a hard call to make at the best of times.
Yeah.
So I'm appreciative of the time, and I certainly don't envisage being able to cover some of the aspects towards the end of it. But again, thank you for the opportunity to address you all on behalf.
Yeah, so I'll just declare a thing or two for you. I have met in the last couple of days with both the management of City Council and the management of PowerNet as well. Try and get an understanding of
Great.
who had what roles.
Thank you.
And also get some idea of the legal implications of who's responsible for what. So I'll be able to clarify that later on. And I guess one of the key issues for me personally will be that at the end of your submission today, I get some idea of what you want done differently, and is that possible?
Thank you.
Thank you.
Yes, the concerns are certainly affecting a significant number of the local ratepayers, and the concern that we have is real. It has a major effect on their livelihoods, physically, mentally and financially. And it's only right that you as elected members listen, take notice and act on their behalf. Approximately a month ago, when the black waratahs started appearing on the road verge along Finlay Road, East Road, Mill Road South, Mason Road and onto Gorge Road and beyond on its way to Arawura, we were under the understanding that they were going to be the installation of fibre. It was leaked to one of our residents who took the effort to ensure that we all knew that it was in fact PowerNet, and they were about to install 29 metre high power poles with 4 crossbars of 4.4 metres wide along a 19.6k line. This has the result of power poles being put on some private residents' land and the remainder following the road verge along this harmful and very damaging non-direct route. The direct route that is proposed has since been emailed to you just in the last few minutes, I understand. We are aware of 3 landowners who PowerNet contacted to enter into negotiations for them to be paid a consideration, not to be mistaken for the word compensation, given that they need to have their land used to put these enormous monstrosities in a semi-residential area. One such negotiation resulted in a bullying tactic by stating that if their land wasn't used, then there would be an alternate route and a more significant number of people would be affected. Another was told that a valuation was going to be obtained to value the harm that was going to be caused for the erection of the pole on her property. She was then told that it would have a catastrophic effect on the value of your home and therefore we would have to buy you out. So the pole is no longer being placed on her land, it's being placed 5 metres from her home on another landowner's property, obviously at a cost that is a lot less for PowerNet. Having received this information over a very short period of mere days, a meeting was arranged to seek some clarification, and a meeting with a small number of residents took place with Mr Shaw and Ms Hurst at the council. As a result of that brief meeting, what I wanted to ascertain was a copy of the resource consent application. The PowerNet Company Limited applied for the resource consent on the 2nd of July, and it's worth noting that the discussions with those landowners took place a month before that was even filed. It only took 15 working days, inclusive of the day it was received and granted, to be approved. The applicant is owned by, quote, consumers connected to the network and is run by the Southland Electric Power Supply Consumer Trust, who apparently also represents us consumers connected to their network. Such trustees are apparently elected by us consumers, and those trustees appoint the directors of the applicant. It's also interesting to note that the applicant owns 50% share in PowerNet and the other 50% share is owned by Electricity Invercargill Limited, whom of course is owned 100% by our very own Invercargill City Council. It reeks nepotism, particularly in light of the lack of detail in the application, the consultation and the speed in which it was obtained to get this completed. Why is it being rushed so quickly? The consent obtained related to 0.6 kilometre section of the new line, in particular a total of 7 poles. There is an excess of 180 plus poles that are going to be erected. PowerNet, at our meeting with them, could not confirm how many residential properties would be affected in this close proximity, but we've done our research, and further on in my paper you'll see it's about 105. The public notification was deemed not required on the applicant's consent form because it ticked the box that says, quote, the consent authority decides in accordance with section 95B of the Resource Management Act that the activity will have or is likely to have adverse effects on the environment are more than minor. And further, in relation to section 95B8 and 95E of the Act, the activity have adverse effects on any person that is minor, and therefore the proposal did not need to be discussed with the consumers. It is simply unbelievable that such a project could be considered to have a minor impact on persons and the environment, as this could not be further from the truth. The personal hurt and harm mentally, physically and financially is clearly visible amongst a large number of our residents within your area. Now, unfortunately, because of the timing of the meeting, most of us work, and we do not have the success, the huge numbers that we've had at other meetings. There are more questions than answered, and as a whole, we believe we have the right to answers before the work commences and to avoid possible further litigation. The following are numerous points for consideration, and this list is not exhaustive, and that is why I've presented it to you, because it covers so many points. A number of lines. Mill Road South will have power poles on both sides of the road. It is concerning with the noise emission, the height of it, if hit by a truck, if trees fall on top of it, it is already a high-risk accident zone. The catastrophic effect on landowners' value, it appears that we have, as I say, 105 houses in the vicinity of the proposed route. If the average price is $700,000 and what we've been told the estimate value will decrease by 25%, it's going to equate to 14.7 million. The compensation for the effect of the loss of value, and even for the trees for some of these residents that are going to need to be cut down because they're on their private land, needs to be taken into consideration. There's been no discussion with those property owners. Some of the poles are literally, if their trees on their land are allowed to be cut down, as in they give their consent, the pole's going to be right in their bedroom window. It's outside their kitchen window. The Seawood Bush Reserve and the numbers that use that tranquil place, how can they be ensured that this place will remain a tranquil place with the wildlife, the environmental impact, birds and bees and bats due to the magnetic field and noise? Road safety, as I say, is already at a very high crash zone. Seawood Bush has been used by numerous ratepayers, not just us residents. The flight path for the rescue helicopter goes over this very route. Due to its size, the lightning conductor, increased fire risk, Asset Management Authority, which we understand have not been informed and are unaware, the lack of environmental impact assessment being carried out, we are unaware of what actually has been taken into consideration. We question whether or not the ICC bylaw of 2016, Code of Practice for Land Development and Subdivision Infrastructure that was adopted by the Council on 1 July, has that been considered? Has the Southland Regional Policy Statement been considered? Has construction and earthworks impact and duration of the works been considered? Has the immediate and long-term hazard to human health, including mental health, been considered? Has the Environmental Reserves Omnibus Management Plan 2021 been considered? Has there been consideration to the impact of insulator leak onto electrical equipment, as in, will our wire fencing and clotheslines need to be earthed? And what we really need to know, on top of all of this, is what real consideration has been given to the alternatives here. We keep getting told it's too expensive. At the PowerNet presentation, we were advised that the underground estimate was 36.6 million and the proposed costing 10.9. But that same gentleman from PowerNet was all over the media, and on the 22nd of December 2023, he states, and I quote, "One of PowerNet's major projects is the $30 to $50 million 66 kV network development to Awarua region." It's been considered. The funds must have been there. I understand it that if it's to be over 20 million, then an application would have been needed to the Commerce Commission for consent, and obviously that would delay the process. There are a significant number of options that the residents have put in bullet point, and they are before you in the presentation, such as building a substation near TY turnoff and take the power from the existing line. There are numerous options that have been outlined here. Does the whole portion of it need to be underground? Could only some of it in the residential areas be underground? The route is not the most directive route. There needs to be consideration for a cost-effective measures being made public, and those costs are actually broken down. How can the most direct route underground or partially underground be more expensive? What is the actual breakdown of costs and installation and maintenance of the underground versus the overground? What are the ongoing costs of maintenance and upkeep? What is the consideration for the residents having to continue to trim their trees when these poles are put in place? The carbon footprint of manufacturing and importing should be included in the cost analysis versus compared to the underground. The route proposed dissects 2 of ICC's environmental reserves, and the scenic classification is defined as preserving the indigenous flora and fauna, indigenous associations and natural environment and beauty for the benefit, enjoyment and use of the public within our own definition in the ICC's environmental reserves. So we question and we fail to understand how the situation and location of these poles are going to preserve this. We understand that the council has imposed covenants on landowners on Mason Road to minimise the visual impacts of subdivision on the assessed high visual values along Mason Road. These covenants require landowners to mitigate any real or perceived visual impacts on the users of Mason Road. These poles will have a much greater impact, yet it doesn't appear to have been taken into consideration. What we want to hear is that we have been heard, that we have an explanation, that given this is commercially motivated, that it should be one that the council should contribute rather than our landowners being disadvantaged. We are here representing a significantly large group of residents acting in good faith. It is clear from the information to date that we believe the resource consent falls well short of what should have been considered, and we urge you and look forward to hearing from you in relation to where to from here in considering our next step. So we certainly look forward to hearing what information that you talked about at the beginning, that
Sure.
you have hopefully be able to clear some of this up.
Yep, so let me run through a few things here, and I'm not attempting to be nitpicky, but a couple of things didn't quite fit right. At the beginning you said the poles are going to be 29 metres. I understand they're 21 metres.
No, 21, sorry.
It's okay,
Absolutely
yep.
should be 21.
You mentioned that the poles on both sides of the road, I understand from PowerNet that's not the case. The existing poles will be removed and the current lines that run down those poles will be attached to the new ones.
So that's not what they told us at the last meeting,
Well,
with all due respect. They made it very clear that it was going to be a double whammy, because we
Well,
all said we're not in Bali.
I understand that.
So someone may have misinterpreted that information to us, but we were told very clearly. The odd line was going to be replaced, but no, 2 lots of poles.
Well, I can only tell you what they told me, and I'm certainly not here to advocate for
Sure,
PowerNet.
thank you.
They said to me that there was the ones that are currently there would be removed, and the current lines would be added to the new pole. So I was quite clear on that. I wrote that down at the time. I hear what you're saying about everything else. I live in Ototara, and if somebody was putting a line like this close to my property, I'd be concerned too. And again, bear with me as I'm only a layperson in this area. It seems to me that the consent only impacts on the Finlay Road end. It's only for a short stretch of the overall project. And I'm not minimising that down. So there are some legal options for you there against the consent if you feel it was inappropriately granted.
That's right.
You have options open to you. On the other side of it, and again, this is my lay perspective, and I asked PowerNet of these questions, and I asked senior staff as well, that running the rest of the way down is what they call a permitted activity, and that gives, unfortunately, the power authority quite a bit of, latitude on where they go, very similar to what they can do with highways and other events as well. So the advice I was given by both staff and by PowerNet was, so long as they were running down the burns of the road, which can be either owned by the New Zealand Transport Association or by council, then they don't need consents for that. They can go ahead. Now, you will argue that there should have been a heads up much earlier on in the process. And I wonder, and this is just my personal view, if they'd given you a public meeting 3 months, 6 months ago about this, would it have changed your view? And it probably wouldn't have, because I can understand the opposition. So, and again, I'm not here to give you legal advice. I think you have some redress on the consent, but that doesn't affect the much wider issue of going where it goes and the commercial decisions that PowerNet have made. It's you made reflections also of the ownership model, and just need to advise that over time we've removed all our councillors off Holdco, which is our holding company, which in turn owns Electricity Invercargill Limited, which in turn has a 50% stakeholding in PowerNet. We did that intentionally because it was really in breach in some ways to the legalities of companies, that companies have to work in the interest of the company, not necessarily in the interest of the shareholders. And so we've been told on many occasions, on not just this issue but other ones, we have limited ability to direct our companies. Well, that's not us opting out. It's just saying that our hands are sometimes tied, I guess. So that's as much as I can tell you from the meetings I had.
Can I ask one further
Sure,
question in
yeah.
relation to PowerNet?
Yep.
Resource consent, we understand that's in relation
Yep.
to 7 poles, and that's what we've got legal advice in relation to our
Yep.
options in relation to that.
Yep.
The rest of us are saying our booms we've got to look after.
Sure.
We can't go and build a bloomin' chicken coop on it
Yep.
because it's council-owned land. But PowerNet can come up and put a big pole in it without council approving as a landowner the erection of this pole, because
Sure.
they're saying it is a permitted activity
Yep.
under the Resource Management Act,
Yep.
and there is no consulting because it's of minor effect.
Well, I won't comment on the minor effect because I probably wouldn't agree with that personally, but I think you need to have a steer towards the Electricity Act 1992, I think it is, because that empowers these electricity companies as well. And so I don't know where that I'm not an expert on that, so I don't know where that leaves them with rights. I think they can do what they want to do.
And so the council did not know at any point that their land was going to be used in this way. When they granted the resource consent for 7 poles,
Yep.
they had knowledge that it was going to be on their land.
Oh, I would assume so. I can't be categorical on that, but to me they are separate issues. Don't get me wrong. We have some input, some legal input on the issuing of the consent, and quite rightly you've raised the issue about, and I think the words you used were, other than nepotism, is it more than minor?
Absolutely.
And you can draw your own conclusions about that. I've already declared my position, but that's just my own personal view. And I'm not here to catch votes today, just to say that when I spoke to management and when I spoke to PowerNet, there are 2 issues with that. One is what we consented,
Correct.
which is a very small area, and then there's the ongoing track through to Arua, and whether, I guess in lay terms, whether the commercial dollar reigns over other rights, whether they're legal rights or whether they're, I guess, community rights or expectations as well. And I can't advise you on where to go on that latter part because I just don't know.
Understand.
Yeah. Questions, councillors? Yeah, Darren.
Thank you. Question is probably of council officers, and either Mr Morris or Mr Shaw might like to have a crack at this, but realistically our involvement is in around what's on our land and is either in an area where it's permitted activity because it's allowed to happen there as of right, and they don't need our permission, they need to consult with us to make sure that they're not damaging any other infrastructure. But on the other areas where, as a transmission corridor under the district plan, it would be a discretionary activity. And in other words, does that mean it would be allowed to take place provided certain conditions were met. Whether Mr. Morris and Mr. Shaw could confirm that for me would be useful. Thank you, sir.
Okay. Rangi.
Thank you, Chair. Look,
Or not.
I'm not,
Alternative.
thank you.
are you still going?
I thought so, but seemingly not.
Yeah, it's you, Rangi.
Okay, look, this question's around the options that were presented to you. Now, in the Southland Times stuff, whatever you like to call it, the day after that meeting, the one you had at 5 o'clock, which is a very awkward time, Michael Fallow interviewed the CE from PowerNet and put some really interesting figures in the article. Now, he gave that the costing of the underground, he gave the costing of the above ground. But the interesting thing that for me was the CE talked about, they think in a 50-year plus thought cycle, you know, a term. So I did some calculations on measuring out your road and Finley Road, and if you undergrounded that and kept the other pylons, the 10 million odd would go to 15. So if you're talking 50 years in the long run, and remembering underground cables require far less maintenance, you put that in 50 years, thinking $5 million is nothing. You've kept the community quite happy, and also saved yourself a lot of maintenance. Now, with these sort of options, because I read online that Christchurch, Orion, put 7.5 k's underground between the Bromley and the Milton substation. No problem at all.
So, no, we got completely shut down, that it was just too expensive. It was completely shut down, and that's what I
It's an
mean
extra
about
five, I just think, yeah.
There's so many other options that we feel were not considered. And then, of course, when the previous article in December 23, and the same gentleman is saying, we've got this project lined up 30 to 50 million, that's what he's saying it's going to cost, is 36 million to put it underground now. Why does the whole lot need to be underground? Why can't they tap into the other resource? He completely shot us down on the basis that it was too expensive, and that in the next 50 years there's going to be other big stakeholders going to be able to join in on it. We said we'll get them to front up with it now. No, they'll pack up and leave town. Well, so will we. Right?
Look, and the
So-
electricity, so I'm trying to get across is that the 5 million doesn't seem much in the electricity industry, and all you guys are good. Now,
Correct.
to me, I can't believe they didn't put that option in front of you.
No.
So it's a bit sad, actually.
And it is on the basis that when we rocked up to that meeting in the pouring rain, and there was over 60 of us there, that
Was it outside?
it might as well have been. It was pretty cool inside. The reality is we were presented with a presentation that was why we're doing this, and we've done all these other areas of Southland. How many houses were affected? Some. Couldn't give us answers. They did not and were not interested in presenting alternatives. It was simply too expensive. And it could go on a much more direct route, tapping into the other internets, and I'm really interested that the answer that you got in relation to the other power poles coming down, because that's not what we got. One lady stood up and said, are you telling me there's going to be poles on both sides of the road? And he said yes. And I know that one of our residents is really upset about, quite frankly, lies and misleading information about certain aspects of it. And if it's going to replace the existing one, well, possibly, hallelujah. But that's not what we have been told, and we were not presented with alternatives. And yet, in 2023, they knew that this $30 million outfit was going to go ahead, and now all of a sudden, oh no, actually no, it's not. It's going to be 10.
So my other question, the last question is, did they talk to you about emission factors? Radio frequency emission?
What we were told was that it wouldn't wouldn't make a noise because they're a lot cleaner than the old pylons.
Oh, this is not noise, I'm
So,
talking.
and that was the only answer we got. We constantly got told, I'll get to that, but after an hour and a half we were getting nowhere, so no. An answer to that question, no.
So they didn't tell you,
We didn't get any of our questions answered.
okay.
It was a really, really poor show of trying to get us on board.
Okay, yep,
I mean, I wouldn't be wasting my time if I thought it was all okay, to be perfectly honest.
okay, Shelley. Good luck. Thanks, Chair.
Just before I go to that, Shelley, we've got some further questions, but yes, I did confirm with PowerNet that the network can be partially underground and partially above ground.
Great.
So it's not an all or nothing. So and Tom can probably talk to this because he's our resident expert on that, being his history. But you can run a line underground, bring it back up, go along the top on the poles, and go back down into the ground. I understand.
Perfect.
You want to talk to that, Tom, just briefly?
Well, technically you can,
Yeah.
but I've actually lodged a question, so if you don't mind, I'll be
Okay,
back and ask
yep,
this
sure.
question. Shelley, could you just clarify for me what it is you wish council to do? I mean, you're obviously a lawyer, you obviously researched the law. You know that under the Electricity Act 1992 and the RMA, we cannot stop them doing it.
Understand that.
Right,
I
so,
want-
so what are you asking us to do?
So our next step is to engage a person that I've got lined up that deals with this type of work, because it is outside of my realms of expertise. I've looked at the Act and I've discussed with her our options in regards to High Court applications. What the people of Invercargill wanted to hear were your views, wanted to have some answers to these proposals, having heard from yourself as to discussions with PowerNet, whether or not PowerNet are then persuaded to look at an alternative route underground, which sounds like is possible. We want to know whether or not the council are able, and obviously you've met with them, that's great, but is there anything that you can do on our behalf? Is there anything else? I mean, not one of us in this room would want a 21-metre power pole erected outside of their kitchen or bedroom window and not say anything. We've met with PowerNet. We've met with you guys. We've had to voice our opinion and not just take it lying down. It's just not on. It's got too much of an emotional effect on a lot of these people to be sitting here and just taking it without raising
Shelley,
the
I know it's not the
questions.
whole answer, but one thing that we did urge PowerNet to do and that PowerNet agreed to do was move poles so that they were not necessarily sitting in front of people's houses. So has that been communicated to you?
So we were told at the meeting that if we were unhappy with the position of pole, there's a little bit of leeway. And so I said, are you going to then knock on all of our doors to say, you're happy with this, is it going to go an inch here, an inch there? Yes, we can do that.
Okay, thank you.
Will that help?
No, look, I just wanted to know that they had, because you told us they were doing that. But I can certainly confirm what the Mayor said, because I attended the meeting, they said that there will only be one set of poles rather than two. That's what they told us.
So Shelley, just as a lay person and reflecting on what Tom asked, I guess, I don't know where your legal redress is against PowerNet itself, which are making commercial decisions that don't suit the ratepayers. Whether you can get access to the directors of PowerNet or the board, as they refer to, and have meetings with them, may be an option, because at this stage you're hearing from, I guess, employees of the company as opposed to the board, which are probably a little bit more politically motivated, I guess, is a nice way of putting it. Might be open to an approach as an initial step to say, hey, you've got some major opposition here. So, yep.
So, sorry, may
Sure.
I clarify that?
Yep.
I mean, I think remember that PowerNet are simply the engineering agents of the Power Company Limited. They have been commissioned to do this work on behalf of the Power Company. So, I mean, I would have thought that actually, if you're going to go down the track that Mayor just said, it's actually the power company that you need to be.
TBC.
And I guess that's the other answer to the question of what we want from the council, and that's, I guess, an explanation as to the granting of that resource consent. And therein lies a concern for us. How was that granted and taken into consideration when you look at the application to tick the box that it is a minor event? That is a real concern that I guess is the...
Yep, so Shelley, I'll help with that. It would be unwise for any of us sitting around this table to give you a personal viewpoint on the consent, given that you may litigate against it. So, and I'm not trying to roadblock you out, I'm just saying that it's a side issue, not a side issue, it's a separate issue from the rest of the network that goes down the road you're talking about. And I think you may well want to challenge the issue of minor and discretionary, which we have both available to us, well, our staff do. The timeliness of the consent, I don't think that will cut much water, but certainly you could challenge the others if you had a wish. So we'll be careful what we say in that, because we'd be compromising our staff to do so. But certainly approaching TPC, which is the power company, is an option for it. But I do have other questions. Ria, I'll come back to you, Michael.
Thank you, Mr. Chair. I was, for the interest of the people that have come along today, the residents that this will be affecting too, I was interested in the question posed earlier by Councillor Ludlow to our officials, was to get their advice on the answer that we didn't get. So I'm wondering, is it appropriate that Councillor Ludlow re-ask that question and we seek an answer from our staff?
The question, Mayor Clark, was simply clarification of the granting of a resource consent under our district plan for what, as a transmission corridor, will have been a discretionary activity. In other words, it can be approved provided that certain conditions are met. Just clarification that is the process under which it is granted.
So I guess the ratepayers are saying that part of that discretion is the classification of the word minor.
Sorry, Mayor Clark, I wasn't asking you.
Oh, sorry.
Thank you, Mayor Clark. Councillor Ludlow. The short answer, Councillor Ludlow, is yes, that is correct, and we also consider the other national planning standards and national environmental standards, including one for transmission. That is all part of that consideration process. But the short answer is yes.
So we're giving effect in the district plan to what is set in the national policy statement above us.
Correct.
Thank you.
You're right, Ria? Is that me? Yeah, Michael.
Excuse me, Mayor Clerk, I just a clarification, just the answer that's been given is only in relation to the consenting component.
Yes.
Cool.
The other is permitted activity.
Yep.
It's not a discretionary, it's permitted activity within the district plan.
Undergrounding, yes.
Yep.
Thank you.
Evelyn.
Kia ora. Look, just there's a couple of things that you touched on that are within my particular knowledge and skill set. Electricity isn't one of them, but you reference Seaward Bush and you reference Metcalfe Reserve. Did the people who spoke to you give any indication of consultation with the Department of Conservation or with the Parks and Recreation in terms of the Metcalfe Reserve? Likewise, did they give you any indication that they had consulted with the trustees of Te Hau Mutunga Urupa? Thank you. So, like Councillor Ludlow, I have some questions that I might want to refer to officers as to how all those matters stand in terms of even permitted activities, because I likewise would have thought that there had been consultation about that. But bearing in mind, these don't normally come to this table. So I'm operating from a different perspective than some of the other councillors who sit on hearings panels.
And they may have, they haven't told us. So the presentation was on the basis of we're doing this because, and we don't have to consult. So we don't know. They may well have but it just defies logic from looking at these things that would have been done, and for it to have been obviously ready to go so quickly if there had been that consultation across the board to all the different organisations, the different bullet points that I've put in that presentation that I just haven't been able to cover. Thank you for more than 10 minutes.
No,
Oh,
just one final thing. You mentioned in your brief that you didn't have a copy of the consent. What resource consent? You did or didn't?
No, we've got a copy of the resource.
Oh, you've got it.
I've got a copy, so no, I said that when we went to that original meeting, that was what I wanted to have a copy of.
Oh,
And
okay.
he sent me that through that. No,
Yep.
he's definitely sent that through.
Okay, thank you.
Thank you.
That was the shortest 10 minutes ever.
Thank you.
Thanks for your input. Right. Where are we up to? Where's my checklist gone to? Do you need that? Oh, no, I've got one. Okay, councillors, just moving on with the agenda. Oh. Minutes of the Connected Murihiku Joint Committee meeting held on the 1st of July, which is a Tuesday.
Sorry, just a point of order, Chair,
Yep.
and that's regarding tab 16. My question is, why are the minutes, I just need an explanation of the Infrastructure Projects Committee from the 6th of August, held for the late feature? Why are we receiving them way later on in the day compared to with the rest of the other minutes?
Hang on, are you talking about tab 15 or 16?
So tab 16 is the minutes of the infrastructure. Why are they way down there? Can someone just give me an explanation, please?
Oh, I can't help you with that.
Is it chronological?
Yep. Thank you, Mayor Clark. The reason, Councillor, they have been put down there is relating to tab 15. It was logical to have the minutes that relate specifically to that item to be dealt with together, rather than trying to have everything done in that minutes. Normally going through the minutes, because we knew that there was going to be further discussion around that, it felt important to have that report that was going to be a topic of discussion present, so that it can be considered as part of that, and then the minute receiving can follow. It was a decision made by staff. It is proposed. Of course, it is up to the chair to decide to take whatever agenda item he wishes in whichever order he chooses.
No, that's okay. I just needed an explanation.
Yep.
Because I was looking for those minutes, because they also contain dialogue about the CCTV program. So
Yep,
yeah, and I
Okay.
didn't want to lose that
No.
in wastewater.
definitely won't lose that. So, did I have somebody move and second the minutes of the Connected Murihiku Joint Committee? Steve, thank you. Failed through lack of a seconder. Yeah, Darren, thank you. All those, any discussions on those? All those in favour? Carried. The minutes of the Bluff Community Board meeting held on the 22nd of July. Is that you, Grant?
I wasn't there,
I wasn't there.
Do you want to do it, Marty?
Yeah, I'll move that.
Oh, Barry, thank you. A seconder? Eh? Oh, Leslie, were you seconding that? Oh, thank you. Any discussions on those minutes? There being none, all those in favour? Carried. Minutes of the extraordinary council meeting on the 26th of July.
I'll move those, Chair.
Thank you. A seconder? Trish, thank you. Any discussion about those minutes?
Yes, Mr Chair. Mr Mayor, if I may, I wish to make a statement from the minutes for 3 matters arising from the extraordinary council meeting which took place on the 26th of July 2026. I have read the minutes, watched the live stream recording of the extraordinary council meeting for guidance, and have also sought guidance the statement was not in breach of standing orders. Firstly, I want to thank Councillor Crackett that while I was out of the country, you raised my specific matter in my statement for an agenda item on page 2, under the heading Recommendations, bullet point number 2, which recommends that Council notes the perceived conflict by councillors. This was a report provided to Council from Chief Executive Michael Day. In my statement, I did raise that specific matter as outlined above. I equally raised whether the Mayor Clark's Let's Go ticket team had declared their perceived conflict of interest on receiving the Extraordinary Council agenda, and if not, then would they do so immediately when item 2 is put before the Council for declarations of conflict to be disclosed to maintain and uphold the integrity, transparency and fairness of our agenda set out on Friday the 26th of July, and the meeting being deserving of that. It was very clear to me the perceived conflict of interest for councillors is straight and relatively quite straightforward, as we all worked with the Mayor in our elected roles as councillors. This was also addressed through the Chief Executive Report and spoken to by the Chair of the Extraordinary Meeting, Deputy Mayor Tom Campbell. The reason why I asked for this interest to be disclosed was because it's a fact that the campaign for Mayor Clark's Let's Go Invercargill ticket, that the councillors shared a financial expense for their campaign. Deputy Mayor Campbell disclosed this himself, and I quote, "The ticket was a means by which prospective candidates for councillors could share expenses." The disclosure directly casts light onto what should have been declared interest of councillors, and I strongly feel that disclosure in itself from Deputy Mayor, the Chair, exposed a pecuniary interest, therefore is a conflict of interest. Mr Mayor, to raise that matter, I have the returned expenses from the elected members themselves that clearly state in that return that there was equal sums of $5,426.80 shared as a financial expense. Deputy Mayor Campbell put the question twice for members to declare any conflict of interest other than the obvious already stated. I do not have a pecuniary conflict of interest with sharing expenses with the Mayor for my campaign, but others in this room did. This was the time a shared pecuniary interest should have been disclosed by those councillors. I feel disappointed that this may give the perception to the public that our integrity, transparency and fairness is compromised. As I've just said, the document discloses what that expense was. So the matter arising is from the summary of the minutes under heading 2, Declaration of Interest, which specifies a query was raised through my statement that councillors of the Mayor Clark's Let's Go Invercargill ticket be excluded from the Code of Conduct determinations and disclosure. This is not what my statement requested. I asked for the perceived conflict of interest of those successful councillors of Mayor Clark's Let's Go Invercargill ticket team were to be disclosed at that time at that meeting. The second next matter arising from the minutes at the top of page 3, which refers to the resolution of the previous Code of Conduct lodged by the United Firefighters Brigade, was still in force, although parts of the sanctions determined by the Council to that particular Code of Conduct sanction were dismissed by the Mayor. The Code of Conduct complaint by Councillor Pottinger and myself did not request the determinations, that they should be based on those circumstances of the previous Code of Conduct. The minutes suggest it was not in the public interest for this council in the third tier of this triennium to make governance decisions or use the tools available for when Code of Conduct complaints come to determinations. Councillor Crackett stated that we have throughout this time worked cordially with the Mayor and had not affected council from delivering its core programs or working together through this challenging time. This is not captured in the minutes, and neither is the evidence from the public this determination was in their best interests. Third, my final matters arising is I became concerned watching the motions put forward by Deputy Mayor Campbell, the Chair, that the public who watch the live stream or recording online may be given the conclusion or perception that those motions were predetermined. I appreciate to wordsmith the motions there were pre-written motions put down by the Chair. Some councillors who made statements of exercising their duties called for the Mayor to resign, called for a no vote confidence in the Mayor. However, this was not put forward due to the fact the 4 motions previously had to be worked through. And at the end of the day, Mr Mayor, I can appreciate that when democracy can be perceived as being lost, one has to wonder what's left. Thank you for hearing my statement.
So in relation to your statement, what part of the minutes are you reflecting on?
I've just itemised...
Are you asking for a rewrite of part of the minutes?
Yes, please, Mr Mayor. The item that's not correct is the declaration of interest, from where it specifies that my query was raised that the councillors be excluded from the Code of Conduct determination and discussion. I didn't ask for that. So I'm
Did or didn't?
I didn't.
Okay.
Yep. Thank you, Mayor Clark. We've got that noted and we'll check the live stream.
Thank you. Thank you, Mr.
Thank
Mayor.
you. Any further discussion about the minutes of the extraordinary meeting on the 26th of July?
May I, Mayor Clark, ask a question of clarification over
Sure.
the use of the word pecuniary?
Yep.
Because in my understanding, a lay understanding of it, if it's being raised, then a pecuniary interest is one where you get a financial advantage. And so that usually relates to some form of payment incoming. And I'm not sure that the ticket team were gaining a pecuniary advantage from that, because otherwise we could go through and question every single decision
I appreciate.
made by council.
Yep, I can
So
appreciate.
that they contributed or had contributed on their behalf some $5,000 odd. I'm just looking for some clarification over how we interpret that as a pecuniary interest. Thank you.
Yep, I'll let Michael Morris give us some advice on that. Certainly my perception of that is exactly the same. If you look at some other councils around the country, we have green tickets, we have Labor tickets, we have ratepayer tickets, people that have, I guess, a similar understanding that come together to lobby for places on council. Certainly if you look at the records of this council, on more than one occasion I've had members of the so-called ticket vote against me. In fact, in the most recent, or I think one of the most recent codes of conduct, I think everybody unanimously voted on resolution 8. So there doesn't seem to me to be any perceived allegiance between the members that came in on the ticket and myself. Michael.
Thank you, Mayor Clark. Very simply, it is, as Councillor Ludlow has said, it is designed and focuses around that financial benefit.
Sure.
So it is looking, I was trying to quickly grab up the Local Authority Interest Act, and instead I've got leave against medical advice, which is, I'm not that effective Googling. But no, essentially it is talking about a benefit and a financial benefit that has been received by the councillor. It is looking specifically at whether there is an interest that that person has received and a financial incentive, essentially, as that such person is then disqualified from being able to make a perceived, clear and uninfluenced decision.
Thank you. Tom, did you want to contribute?
Sorry, I was just trying to clarify, because I never quite heard everything that Ria said. Can I just ask Ria what you are asking for? What are you proposing should be an outcome of what
Thank
you've
you.
raised?
What I'm asking for, as I did in my statement, was for that conflict of interest, which was financial, to be simply declared.
So is that the only question? Is that the only thing you're
That's-
asking for, is clarification of that?
I'm sorry, Tom, I asked for that conflict to be declared because it is a financial interest. It's a financial conflict, that a pool of money was shared between 4 councillors and the mayor. It was more conflict than a perceived conflict of working with the mayor.
So you're asking, sorry, I beg your
that's what I was
pardon.
asking
Yeah,
for.
so you're asking for clarification about whether that would represent a pecuniary interest that should have been declared.
No, the perception, Councillor Campbell, is that there was financial interest or expenses shared between candidates that was not disclosed.
Okay.
At the two
So,
times
so
that
you,
the
so
answer
you're
was
just
disclosed.
trying to cast aspersions. You're not actually asking if it is a pecuniary interest, because clearly it's already been answered
Not
that it
casting
is not
aspersions.
a financial interest by
I'm not-
definition.
I'm bringing it up as a matter arising from those minutes, that this was not disclosed at that time when 2 opportunities were
Because
given.
it did not have to be, because it was not a pecuniary interest.
It's a financial interest, it's more than a perceived interest.
It's like you sharing a taxi with another councillor and saying
No, I'm
then 2
point of
years
order,
later.
I'm point of
there's a-
order, councillor, I'm trying.
No, hang on. Point of order come through me.
Sorry.
So, and we can't have debates across the table the way they're going. It's getting unruly. Tom, do you want to finish what you want to ask?
No, that's fine.
Yep, thank you. Alex.
Thank you, Mr. Mayor. I take your point, and I also take Councillor Ludlow's point around the fact that, you know, when you look at it as if it is a pecuniary interest, nobody had anything to gain after the fact, after the day of the election, when it came to the contribution of that that particular $5,000 funding that you all shared together. But I think the community perception that I was hearing, and why I felt like it also needed to be raised, is because there is a financial and pecuniary benefit that members around this table have advantage to, because they get put into positions that have
No,
a financial
councillor,
gain.
I have to stop you there.
That's why I
No,
believe
listen,
that it's
I'm
important.
chairing the meeting. I have to
Yeah.
stop you there. That is going one step too far. If you are suggesting that the appointments I've made are made on a ticket basis, you need to look really hard at the positions that I've appointed. You've raised this with me very early in the term. You can't start throwing grenades around like that.
I'm not throwing.
Well, you are,
Respect-
because
respectfully, I'm just saying
we've
that
already had the decision made.
I believed it was important to note. That is all.
Well, you're raising issues on what you say are perceptions of the community.
From
In fact,
members
we've
of
already
public
had
that have
a
expressed that to
definition of
me.
what pecuniary gain is, which is what you have to declare. Now, you're not suggesting at any stage that anybody in this room has got pecuniary gain because they came in on the ticket.
Mr. Mayor, I'm suggesting that I supported the notion that it be declared at the meeting. That is all.
Well, hang on. Let me ask you one other simple question. I've got a notice of motion on the table today, and I've also got an amendment to come over the water consent. Does that mean anybody that came into this room on the ticket, as you refer, should not be able to vote because I've put forward those two issues?
On what, sorry?
Well, I've got two motions up today that I'm going to put. Are you suggesting that those that came in on the Let's Go Invercargill ticket, who are sitting around this table now, would be compromised?
Mr Mayor, may I just ask a question that might help?
Yep.
So Councillor Bond, is your question around procedure merely looking for, because it was dealing, the matter was dealing with the Mayor, who was the leader of the ticket, and the meeting was being chaired by the Deputy Mayor, who was also on the ticket. Would you have been satisfied if there was simply a statement going, the members of the Let's Go Invercargill campaigning team have had no discussion or declare no conflict of interest? Is that what you
That would
would
have
be
been
looking
a simple way to actually work around that, the process taken.
Thank you.
That would have
That's
been,
exactly what was said. I mean, that, if you look back at the live stream, I said exactly that.
I invite you to go back and look.
No, you go back.
I think this is getting increasingly emotional.
Yep.
It doesn't have to be.
Correct.
Councillor Bond has asked for a very simple matter which she has raised quite legitimately from minutes recorded from an earlier meeting.
Yes.
She's made a very simple point about what could have been recorded quite simply that would have satisfied why she has raised this matter. The appears everybody on the ticket is admitting was the case.
So you're right, councillor, but two things with that. I listened to the live stream of the original meeting, which is the minutes of the 26th of July, and the chair, who was Tom, clarified that position quite nicely. So I don't know why it's resurrected again today. I gave licence to Councillor Bond today to read a statement, which I should not have done, and that's my error, because the minutes are the minutes. And at the end of that statement, all the councillor wanted was to correct what she saw as an incorrect statement in the minutes, and that I would have tolerated. It wasn't the place to read a statement out, so I'll learn from that. So any further discussion about that meeting?
I'm sorry, Mr Mayor, but a simple request to change a couple of sentences in the minutes to record what it would appear everybody is agreeing
Yep.
was what was conveyed at the time.
Yes.
Seems like a reasonable request.
It was, but Councillor Bond spoke for 3, 4, 5 minutes in a predetermined statement, which went on beyond just the inaccuracy of what the minutes said. Trish.
I agree with Leslie that it is just a simple change to the minutes based on number 2.
Yep.
I also would just like to draw everyone's attention to the fact that we have an issue which is pecuniary or what, and so people who were asked to declare a conflict of interest, from their point of view and from what they understood, they chose not to, and we can't say that they were necessarily wrong.
Okay.
Through you, Chair, I actually asked the question twice.
Yes, you did.
So we asked the question, or asked the question. The only person that declared an interest was Evelyn, who explained that. At that point, Councillor Crackett raised the issue that Councillor Bond had raised. I provided an explanation of what the ticket was, and I think I actually answered the point that others had made. But I then said that I will ask the question of individuals again, having had that clarification. So I again asked individuals whether they had any declaration of interest given that discussion, and nobody declared an interest.
Yeah.
So, I mean, I think it was totally aired at the time of the meeting, and I'm not quite sure what point was trying to be made, to be honest.
Yeah. Okay, any further discussion? Somebody like to move the minutes with the amendment that Michael has acknowledged? Michael Morris?
It might be useful if Michael just repeats the alteration that would be made to the minutes.
Thank you. What we will be doing is looking back at the live stream. It is likely that we will be doing that section verbatim, which is not our normal practice, but I think that will deal with this issue. It will capture it in its entirety for everyone to be satisfied what has and has not been said on that day. I think that's the only way we can do it, in which case I would probably ask Mayor Clark for these to be left on the table until the next meeting.
Any opposition to that? So be it. It gets left on the table till the following meeting. Barry, did you have your hand up? Sorry, I missed you.
Yeah, I'm a bit disgusted on some of the comments that some of the councillors are making about at no time is any of my decision making any part of Let's Go Invercargill. I make my own decisions. I don't put it all on what's on Invercargill or being a member of that. And I'm a bit disgusted that this is being brought up here at the moment. Thank you.
Okay, so we've left that set of minutes on the meeting, of that meeting, on the table to be brought back to the next full council meeting with possible amendments subject to the live stream. Thank you. Minutes of the council meeting held on the 30th of July. A mover and a seconder. Thank you, Darren.
Second.
Leslie, thank you. Any discussion around those minutes? There being none, all those in favour?
Excuse me.
Oh,
Councillor.
sorry, yes,
I've got a gesticulation.
sorry,
Sounds like you need some more.
yep,
Thank you, Chair. Look, The minutes show the museum project with an increased 13 million design budget increase, $6 million external funding shortfall, so that's $19 million more than what this council agreed to on the 22nd of August last year. Now, last week at the local government conference in Wellington, Prime Minister Luxon addressed an assembly of council leaders and told them quite clearly to rein in their fantasy projects and focus on delivering affordable, quality infrastructure. I now see this museum project as the poster child for what Christopher Luxon was actually talking about. Section 101 of the Local Government Act states a local authority must manage its revenues, expenses, assets, liabilities, investments, and general financial dealings prudently. At a recent tourism conference held at the Ascot Hotel, our mayor was quoted, and this is in the 8th of August Stuff article, quote, "I want the museum to be the flashiest you've ever seen." If you go online to the Local Government Act, there's a wee search window there. And if you type in flashiest, you don't get a hit on the Local Government Act. So I want to quote the Prime Minister once more. We need to rein in our fantasies. And I am speaking to the minutes, because when I look at the minutes, there is nothing about what I asked for, that we should be stopped because we've breached our significant engagement policy, the option of using the old farmers building, which would see a potential saving of tens of millions, questions around why in June the budget in our projects committee showed it was on track with a $6 million worth of contingency, and 22nd of August 2023, when we voted on this, we were told that the budgets had all been stress tested. The extra $6 million that was asked for was to cover things like the wow factor. Look, these minutes do not accurately sum up that meeting. So if you want to put them on hold and do it again, because I'm not sitting here accepting these.
Excellent to have that comment. I make no apology for saying that we want the flashiest museum in the country. It's an aspirational thing that most of the councillors around this table have aspired to. At this stage, the Prime Minister, while he voices an opinion, does not have an ability to rein us in on projects that we're already 3/4 of the way through. If you consider there were 3 projects bundled up into one, and he didn't say that there would be a full cap on rates. What he suggested was that we should not be off into nice to have were the words he used, and I think that having a museum, or alternatively in the future having an art gallery, is not a nice to have, it's a core part of delivering to our ratepayers. Alex.
Thank you, Mr. Chair. I did want to just clarify that piece because Councillor Pottinger is quite right that the Prime Minister did say that he would like us to do the basics brilliantly, and he did specifically quote pipes, roads and rubbish. But the National Party went on to be questioned about that, if that was only what they considered council core business to be, and it was stated that actually museums and libraries were included in that core business. So we are still doing a museum and we're still keeping our libraries and pools and such open as well, I hope.
Yeah, thank you.
Mayor Clark, as the mover of the motion, can I just clarify that the minutes are there to recollect the decisions that were made and not reflect all of the debate that went on. Councillor Pottinger is right, he did raise those points.
Yep.
It's just the reason I raise it is quite selective, and it's the way it's printed. So it may have been edited to take out negativity. I'm not sure.
Well, you can't cast aspersions like that.
It's not
No,
it's a
No, Councillor, we can't have the debate across the chamber again.
Apologies.
And you're quite right, Darren. We've been over this track before, whether we hold verbatim minutes or not. It's reasonable that staff make a pretty good fist of doing it. I've only seen one set of minutes in the last 18 months that's been word for word, and the rest is a coalition of thoughts. If you want word for word, we should say so right at the beginning of the triennium, and we will have minutes that are just miles long. So,
I think, Chair, it was just a balanced, it showed there was a balanced debate.
Yep.
Okay, so in my opinion, it doesn't show a balanced debate.
that's right, you're entitled to that opinion. Any further discussion, Leslie?
Thanks, Mr Mayor. As the seconder of the motion, I just wanted to make the point that we long ago agreed that verbatim minutes were the exception, not the rule.
Sure.
And these minutes are a record of a meeting that took place in
Yep.
the spirit in which this council has operated.
Yep.
I also want to add that the discussion and the way in which Councillor Pottinger raised it is an example of why the quoting of political leaders at council tables is inappropriate. His remarks, as Councillor Crackett has emphasised, were taken out of context and without the full story of what was actually said at the conference and the answers to other questions after the Prime Minister's speech. To me, it has become a completely ridiculous issue if we are going to have political leaders of particular political parties quoted at this table as though what they say is the gospel on every action. And to have that further taken to the point where we are told that our very legitimate long-term museum project has somehow become a poster child for everything bad the Prime Minister may have been talking about is a completely ridiculous statement to bring to this table, and I actually find it quite offensive. It really does show the dangers of bringing party politics into what has, for all of New Zealand's history, been a non-party political local government. I just want to make that statement quite clear, that this is just something I do not want to see the lines being stepped over on.
Thank you for that. I've got a mover and a seconder. Any further discussion? All those in favour?
Aye.
Carried. Minutes of the Connected Murihiku Joint Committee held on the 5th of August. Oh, sorry, Councillor Potton, did you wish to vote against the last motion? Not with me? Okay. So the minutes of the Connected Murihiku Joint Committee meeting held on the 5th of August. A mover and a seconder. Steve, thank you. This is a chance for somebody to be a seconder.
Yes.
Can do that.
Yeah, thank you, Leslie. Any discussion about those minutes? There being none, all those in favour?
Aye.
Carried. Minutes of the hearing of the dangerous and effective and sanitary buildings policy held on the 13th of August.
Thank you, Mayor Clark. If I may,
You can.
because now I can speak rather than just be restricted to asking questions, and thank you, Kylie, for staying around for this, and on behalf of the committee, our apologies that your submission was lost. It shouldn't have happened, and we'll be taking extra care to make sure it doesn't happen again, because it's not nice to have to sit here and say sorry for something we shouldn't need to be saying it for. The points raised around expert witnesses are very interesting, and what I was trying to allude to is they are not gods. So in a resource management process, you can have an expert witness on either side of the party, and there is a collection of behaviours and rules that an expert witness has to comply with when presenting. In other words, their evidence can't be advancing a particular area. It's got to be neutral. So simply having somebody who's got a qualification in something doesn't necessarily make them an expert. It makes them qualified at what they do. And there are tests through the hearings process that those witnesses need to make. I mean, I had in the previous council, you'll recall, an expert witness during the 2.5-hour discussion we had around vaccination mandates, who was a doctor, and interestingly was struck off not long after appearing in front of us. So I'm not suggesting that the experts that you had fit that, not in the least, Kylie, but it's just that just because you've got a report from someone with a qualification in a specific area doesn't necessarily mean. Now, I didn't go through all the documentation around the hotel project because it would do my head in. I don't do it unless I have to. I watched with interest, obviously. And so that's why I was trying to come back to the policy, and it really comes down to Councillors Bond, Soper and Mrs. Coote as to whether you feel there was a need to make an adjustment to what was in there, and I have highlighted it. Thank you, Kylie. The statement that in lieu of expert advice, the following will be, or in addition to expert advice. I understand the intent of the suggestion, but I'm not sure that it's not subjective. When you're looking for a particular outcome, there will be frustrations that come along the way. And that can be from council side as the receiving organisation as well. A lot of what people submitted to on the policy were changes that they were looking for that were actually acts of parliament that the policy is giving effect to. I don't think this actually quite fits into that category, and that's where I'm trying to find its place, Kylie. So I have listened, and I wonder with that in mind, if from the staff there was any opinion around the wording of the part of the policy relating to expert advice. I personally, and I'd really like to hear from the other committee members, don't see a change as screaming at me. I'm open to entertaining one, but I'm not sure it is as profound a problem as it was presented. I get the frustrations with the process that come through it, and that's after quite a number of years of dealing with people who weren't necessarily getting applications the way that they wanted. But Mr. Shaw or Andrew or Mr. Morris, if you had any suggestions.
Let me put it this way, Darren. As chair of the committee, and you've got some recommendations in front of council now, is that something you'd like to pause on and give some consideration to?
Yes.
Till I can put this
I
aside.
would also like to hear from the other committee members, or do you want to wait to hear back? I mean, Leslie?
Thank you, Mr. Mayor. If you're okay for one of the committee members to make a comment at this point.
Surely.
The weighing up of expert or non-expert advice on either or both sides is a part of what hearings are about.
Yep.
We would not have hearings if we were not considering the weight of evidence on both sides.
Yep.
I listened carefully to the suggestion for adding, I think one of the phrases was in lieu of expert evidence, and sorry I can't quite remember the other phrase, but I didn't see from my point of view that it was actually adding anything that was not already inherent in the hearings process, where we are weighing the evidence and as a panel coming to a conclusion, having weighed all the available evidence.
Okay.
I'm interested to hear staff views, but my feeling is that the phrases suggested are both already catered for in the very reason for which we have hearings.
Thank you, Mayor Clark. Through you, I can ask the same question of Councillor Bond and then Mrs. Coote.
Sure.
Thank you, Mr. Chair. I also was interested when I read through the statement, the submission, Kylie, where you had the, I guess, the request to add in lieu of expert advice under the following will be, or in addition to expert advice following. So I went back and looked at what our considerations were in that hearing and the submissions that went there, and I left with the question to myself of as Councillor Ludlow said, you can have in the room two experts having a complete difference of opinions in their specialisation, and the hearings role and the staff's role, as well as the chair and the panellists, is to actually work through that, caucus it out, so that we can then ask the two experts to come to a decision that is a mutual decision with the expertise. And I feel that at the moment, currently, this policy provides for that to take place. And that's the determination I came to.
Mrs. Coote.
I just want to also acknowledge actually the difficult and challenging time that the actual Love West Festival actually experienced, because it was probably really a hard time for the Bluff community, and to have an expert tell us, I was a past committee member, so I am disclosing this on the Bluff Oyster Festival, but
Bearing in mind, I'm asking about the policy. not-
I know, but in saying that, to have an expert advice being provided and noting that this is a dangerous building was devastating to see that it took a couple of years to amend in some way or form to address. But in regards to the policy, I think, we need to probably consider other expert advice that is tabled and take that into consideration.
So, reflecting on that, it sounds like the committee's comfortable with where it's at. I mean, the submitters raised a really good point, and I think through our processes, we, and that's council, both through the hearings panel and staff, need to be cognizant, and I'm sure the staff are, of expert advice when that comes in. Because we don't hold all expert advice within council, we are able to contract out and get that under the same terms and conditions of expert witnesses, and that's why that is done from time to time. So I'm not sure that the alteration that's been requested is going to achieve much. As Councillor Soper said, it's a little bit of wordsmithing, but it doesn't change the intent of the policy. So with that in mind, I'm going to move that we move the recommendations to council, that we adopt the draft dangerous, affected and sanitary buildings policy with the changes as agreed to in resolution 5.
And I will second that.
Yep, and before we go any further, I'll give Michael an opportunity to contribute.
Through yourself, Chair, I was actually going to say that it's unusual to have a submission late after the piece, and apologies in relation to that from operations perspective. But having myself listened through the processes, just undertaken whether that would have altered the panel's position in relation to the recommendation, we would have had to have gone back in relation to seeking the advice and share it at the table to do that, and then the panel would have to make a call. From my perspective, there's now a motion on the table in relation to that, and I'll step aside and not let not go to the council staff in relation to that, because I don't think it would add to the discussion.
Thank you. So, Mayor Clark, thank you for your indulgence. I'm happy to move the recommendation to council that council adopt.
Seconded by you, Leslie.
Yes.
Yeah, any further discussion? There being none, all those in favour?
Aye.
Anybody opposed? No? Carried, thank you.
Can I add our thanks to Mrs. Fowler for raising the issue with us?
Sure.
It's good to test it.
Yep. So moving on to item 10, which is the minutes of the Community Wellbeing and Regulatory Committee.
Move that they be received.
Yep. Seconder Grant, any discussion about those minutes? No, all those in favour?
Aye.
Carried. The minutes of the extraordinary council meeting on the 13th of August. Mover and seconder.
Move those.
Thank you, Leslie. Grant, any discussion about those?
Yes.
Certainly. Rangi?
Thank you, Chair. Look, I actually wish to speak to item 3, which is the apology made by yourself at that particular meeting.
Yep.
And because I wasn't there, and I thought the apology would have been at today's meeting. So As a complainant, I have to state publicly I do not accept this apology. The investigator's report confirmed and validated all 4 code breaches submitted by Councillor Bond and myself, including the process that we undertook in lodging the complaint. So from my viewpoint, the apology did not account for the demeaning comments made by the Mayor about Councillor Bond and myself regarding the code of conduct process, and also the alleged reasons behind the motivation for us lodging the complaint. Also, the apology did not recognise and acknowledge the actual cost of the investigation. And the reason I state this is because it could have easily been averted if on about the 19th of April, the Mayor had apologised in the given 5-day window of opportunity. So I'm not expecting another apology, but I wish to state publicly that I'm not accepting this one as one of the complainants. And I don't know whether Councillor Bond wishes to speak, but I've said my part.
Yep, you're welcome to that opinion.
Thank you, Mr Mayor. At the time when this meeting took place, I aired under the apology my understanding of when that was to take place. And I think we went through and discussed, had a discussion about this, and I think my comment was que sera, que sera. Lodging a code of conduct with a colleague is never ever an easy position to come from. The apology opportunity that was provided would have resolved everything. There's no doubt about that, and that's been shown in the evidence provided. From the apology that was given by the Mayor, I felt that he was very genuine when he thanked his deputy, Tom Campbell, for putting out the fires as such through that challenging time. It was mentioned from others that they didn't feel that that apology was satisfactory and didn't hit all the areas that it needed to hit. And my position then was I had to silently agree, otherwise am I going to be labelled as being someone that's a troublemaker and won't accept the outcome. So I guess for me, I felt that it was important that I just accepted that that process was uncomfortable in every which way possible with the apology.
So in response to both those 2 issues, I draw your attention to the extraordinary council meeting on the 26th of July. Recommendation 2 says the following: that a sincere apology be made, that's by me, in person and in public at a full council meeting. I did exactly that. It didn't say I had to apologise to the 2 councillors who raised the issue. It did not say I had to apologise to staff. It did not say I had to apologise to mana whenua, which was raised at the last meeting. I made a genuine apology that followed up 2 other apologies that I already made on the same thing, both publicly. And I don't know what tea leaves you're reading, but the community have had an absolute gutsful of this. This constant litigation. And the message I keep getting, and I guess some of my colleagues will be getting, stop apologising, you've done enough. And I've made apologies in writing, in the media, and now face to face as I was required to do. We shouldn't be relitigating it again today. You've got a mechanism in October that you can critique what I've done around this apology and also what I've done by way of my behaviour in the intervening 3 months. So unless there's some inaccuracy in the minutes that are recording that meeting.
Excuse me, Mayor, just in response to that, and I think I deserve just a very small reply, is that are you happy with the comments you made during that time about Councillor Bond and myself and the process we took? So you're fine with that? You have no problem and the motivation that drove us to lodge the complaint. You're happy with those comments that you made?
I'm not going to relitigate it. You've had your day in the spotlight. You've had me investigated. The investigation clearly stated that I was to apologise. I have apologised.
No, I think you've answered that question.
That's right. I've apologised and apologised and apologised. The error is at my end. I haven't said the error is at anybody else's end. It's only so much you can continue to apologise.
For heaven's sake, let it be, councillors, would you? Can we just move on from this?
Yeah.
Excuse me, point of order. Look, I don't want to be berated from
Well,
the
hang on.
chairman of
Slow
the
down.
board. Yeah.
Slow down. The
I've
deputy
already
mayor.
been told in an email to get a hobby, so
Well,
you know,
that
I think
if you wish to raise that, you're welcome to raise that. But that's not from me, and this is focused on me. So, yeah. Peter.
Thank you, Mr. Mayor. I travel in a lot of different circles within our city and our region, and to be perfectly honest, the amount of people that have said to me, why are certain councillors asking our mayor to apologise at every opportunity at a council meeting? Look, the people out there, the same as me, they've had a bloody guts full of it. Let's put it to rest once and for all. Thank you.
Any further discussion about the minutes? A mover and a second, please.
I think you've got it.
Oh, thank you. Okay, any further discussion? All those in favour?
Aye.
Anybody opposed? Yes. Councillor Pond, you want your vote recorded against?
well, against receiving them, yeah.
Yep, thank you. Minutes of the Risk and Assurance Committee held on the 15th of August.
Happy to move those.
Thank you. A seconder, Grant, thank you. Any further discussions on those? There being none, all those in favour?
Aye.
Carried. We now come to the notice of motion. I take it as read that that you've read the attachment that goes with it, and so I'll move the notice of motion, and as the mover I will speak to the motion before I ask for somebody to second it. So this motion has come to me for two reasons. One, I feel that our ability to dispose of the agricultural farm, referred to as the agriculture and events area, has not moved at enough pace. I recently was party to the master plan that's being developed for Donovan Park, and I have to say, given that we don't have to do a master plan, we're not required by the Act to have one, to receive a master plan that's nearly 500 pages long and generates quite a bit of interest for the farm area as well, is a little bit concerning. But I want this matter brought forward so that we can get some resolution to the process internally, that we process the application off to the Minister of Conservation for a revocation of the reserve status on that farmland, so that gives us options going forward. And as Michael Day has said in the past, the fact that we change the status of a reserve does not mean that we dispose of it. It just means we have some options. You heard the Prime Minister and the Minister of Local Government make reference recently to potential caps on rate increases that would be deemed to be closer to the rate of inflation as opposed to being 2 or 3 times that amount. And I think it's important that going forward that we have revenue sources within our structure that allow us to deliver a better level of quality of service to our community that's not based on potential restrictions on rates. And so this does that. The second thing that the motion does, in line of that, it also allows us to advance the issue of housing, which we've really struggled with, probably for a couple of decades now, and it frees up land that could be used for elderly care or for retirement villages as well. And the final part of the notice of motion is to get a report back from Jonathan's area about the level of intensity that we can have permitted in the city. I've had a lot of developers approach me about the potential for intensifying housing on land, and I'm a lay person in this area, and I think many people around the table don't know what our current criteria is and what discretion we have around that. So it would be helpful to get a report that identifies what levels of intensity we can go to. The alternative the government says, if we don't intensify our housing, is to show that over the next 30 years that we have adequate housing, adequate property available for housing going forward. And I think that's too difficult to show long term. So I've put the motion with its 4 recommendations. A seconder for that?
I'll second you.
Yeah, Tom, thank you. Any discussion about the notice of motion? Rangi?
Look, I'll jump straight and quick. I noticed in our consultation document today on Donovan Park, it asked the public about the potential for maybe housing development. Now, to me, this came as quite a shock, because in late 2022, I think it was September, there was a national policy statement on highly productive land. And if you read that, it's been updated this month. It specifically states that unless you've made clear indication well before that date, you have no hope of changing the status of what is now high value soil under our district plan. So if you remove the reserve status layer, that's what is left behind. Rural farmland, highly productive, high value soil. So there are examples currently in Invercargill of people trying to use land that comes under LUC 1, LUC 2, LUC 3, that's land use capability, and they are stymied. So I'm not sure why we had a consultation document that provoked thought about this option when it was post this policy statement being released. Now, obviously, to get clarification on this, perhaps is there a staff member in the room who's a specialist on NPS HPL?
Jonathan's grabbing a microphone.
So through you, Chair, it certainly sits within my area, although I would not describe myself as an expert on the NPS HPL, but yes, as I understand it, Donovan Park is classified as Class 2.
Yes, it is Class 2, yeah. And which means that all you can do on that land, if you remove the classification, is farm it. So I'm just wondering where this real estate idea has come in. Can someone talk me through that? Because this is legislation. This is not theory or personal opinion. This is legislation.
Well, I've been driven by 2 things. One is that the Parks team have put to us about 2 years ago a list of 16 properties which they thought should be disposed of. So I've been active in that area to try and dispose of those areas, given that they free up land for housing and they also give us a revenue source as well. And Donovan is on that list. So that's the advice we get from Parks. So I'm assuming, given that they put that up on the list for disposal, they weren't considering disposing it to somebody to farm it. And I think for most people, it would be a bit of a stretch to say that the Donovan farm was highly productive agricultural land. So in good faith, I've been asking the staff to change the reserve status on the land so it can be used for residential. Darren.
Thanks, Mayor Clark. I'm speaking against the notice of motion simply from the perspective of it's stampeding towards an outcome. I've talked with various members on occasion around the process that you've got to go through. And I genuinely have an open mind on it. I have no preference for whether or not there is part of Donovan Farm that is turned into residential or not. It is worth me at this point making you aware that when we do get to a hearing process which is required, several of you will not be able to participate in that because you've been very clear in your expectations, and that's fine. I mean, you're allowed to say that. There's a really high test in changing this land over, and we can expect a reasonable degree of scrutiny on it from a couple of perspectives. One, the ratepayers, but two, the minister who has to make the decision, who also happens to be the MP for this electorate. So one would hope they have an intimate knowledge of the particular piece of land at the centre of it. Wednesday, week ago, Councillor Campbell, Councillor Bond and myself attended a public meeting at the Waikiwi Rugby Club around the Donovan Park management plan. And while there were some people who were talking about the management plan, there were also some people there who were interested in understanding what the process was around the views that the Mayor had articulated through the media. Councillor Campbell alluded to the financial reasons why and the benefits of what any monies raised would be able to provide to the city. I talked purely around process. And if we were to take the notice of motion and lodge an application with the Minister of Conservation based on the work that we had done, I don't firmly believe that we could call the consultation on the management plan consultation for that level of decision. And it's just going to get head-butted back to us by the Minister and go, no, you need to be more specific. Furthermore, that was also the assurance that we gave people attending this meeting, simply because it's the process. And people who know me will know, much like Councillor Pottinger is a man of science, I'm a man of process. And we can go out and consult on it separately. It doesn't need to take forever, but I'm worried about some of the timelines in here, Mayor Clark, and that's my concern, that we get it lodged by the end of November. Geez, that's a real squeeze. You could do consultation, but if I was somebody who was submitting to it and we were given, 2 weeks to consult, and then the submissions have to be processed, a hearing has to be held for those who are able to hear it, I would be going, oh, how legit is this? The last one around management providing a district plan report to full council around the level of housing intensity by next month is, I've got to say, virtually impossible, unless they stop doing all other work. It's not a hard question, and it's a fair one for us to ask, so as a council you can understand where greenfield development, the sort of stuff you're looking at Donovan Park, and brownfield development, intensification on existing sites can happen. But you've also got to understand the perspective of the developer. They are in business and are there to maximise every dollar out of the property that they can, and they will always push the envelope and look to go below what is permissible. What could just get a stamp and not have to come to a hearing. Quite often they choose to go to a hearing, and that's fine, because sometimes through that process we can find ways to make it work. It's about making sure that there's amenity, because if somebody goes and throws a dirty great big power pole up outside your house, you see what happens. There are arguments for extending the residential boundaries, and there's actually already areas identified in the district plan for where the next one could go. I note the landowner for that particular property was present at that public meeting, and I talked to them directly about it, and they are of the understanding that if they want to exercise that right, that there's some infrastructure that they are going to have to put in place. Because I can tell you, as a resident in that area, it's pretty much tapped out. You can only fit so much down a pipe. And so if you want to try and squeeze some more in and out, you need bigger pipes. And that's a big thing. It's doable, but it's not easy. It's not just a simple bolt-on. So the outcome is still open. My concern and objection is around the timeline, the shortness of the process, and the not specifically going out and giving people a genuine opportunity to say whether they support or do not support it off. Because I can tell you, when I was at the AMP show earlier this year, there were people who supported it. They were interested to make sure that the strip of land up the middle of Donovan Park, particularly scenic strip that leads up through the duck pond, that remained. And we saw at that public meeting some very exciting developments. It's not necessarily the piece of land that's being looked at. So, you know, who knows? That there could be an outcome that the council is able to arrive at. I just don't see us being able to arrive at it in this time frame. And if we tried to, which you can vote for it if you want to, and we can have a crack. But it's a lot of money. And I don't want to waste it at the moment. Thank you.
Evelyn.
Tēnā koe. It will probably come as little surprise to you that I too am opposed to this motion. I don't get to vote, but I do feel the need to speak to it. We have just gone out to consult with our community. We are telling them that we want to know what they would like for Donovan Park, because this is a democracy. It is not an autocracy, it is not a plutocracy. If people wish to build housing in Invercargill, there are still places and spaces where they could. There is a subdivision waiting to be built just down below where I spend most of my time. And it's not happening. If there was a demonstrated need for housing in this city that people could afford, that they wanted to buy, that person would be in operation now. He's obviously not getting the demand, or he would be building. If we're talking about building for people who think that they're too good to live south of Tay Street, I think that's sad, because this is one of our crown jewels. We only can do this once. The public, the ratepayers, the owners of Donovan Park, we're the kaitiaki or the tangata tiaki, the mana tiaki of those places. But the people who own it, we're just part of them. We need to listen to what they have to say. And I think this notice of motion actually indicates to them that some of us have made up our minds already. And I think, along with Councillor Ludlow, that is not good process. We need to be consulting in good faith. We need to be prepared to listen to what is said. And what this notice of motion says is, no matter what you say, we think we should actually be selling this off and building on it. I don't think that is a message that this table necessarily should vote in favour of. Having said that, I recognise fully that I do not have a vote. But my voice is for the people, for the status of those special places that are not yet taken from us for development, where we can still go and recreate, whether that be that we ride our horses or have a show or have other kinds of events. I was quite excited by the opportunities in the consultation document, many of which I had not thought of, and admired the thought processes that had gone into the consultation. I would like our citizens to be similarly able to be excited, be stimulated, and respond to what is an opportunity for them to speak. Thank you.
Michael.
Thank you. Through yourself, Mayor, I'd just like to number of probably about three things in relation to this, and one is to remind Council that we've already had a discussion document in relation to the management plan at a Community and Wellbeing Committee, where it was already put on staff to actually begin the implementation plan in stage 1, was to actually investigate the future use in relation to the aquaculture and events area. So what I would say to that is we have already begun the process in relation to what you are seeking in here. However, the points made by the Councillor Ludlow in relation to the process for revocation, and also in relation to the highly productive land process, this would actually, as going to revocation straight away, without a fully formed position in relation to the use of the land, is one of the processes that would get a decline straight away. And I say that because it is in the process from perspective of going through the MPS. It is harder on a level 2 than on a level 3, but it's very clear unless you have a very defined purpose with the lodging of that application, then the revocation does not tend to be lifted. The other item, I would say, it is noted in there for item 3 around the housing intensity. Obviously doing a report in relation to that is something that council staff can do, and absolutely we can get that information back. We have provided a number of the requests to this in relation to like long-term plan information, and it is later in today's report in relation to the CE's update. What I would highlight is if there is information gaps in relation to that, we do not currently have, this would provide, but we do not currently have a report request sitting as is indicated in this notice of motion. There is no outstanding report relating to this. Should council decide to approve notice of motion on item 3, we will follow up from a staff perspective. Should council approve in relation to items 1 and 2, staff will do their best to endeavour to achieve those outcomes. I'm just highlighting the risk that would impose, and particularly around the process which has been expressed to you by by Councillor Ludlow.
Leslie.
Thank you, Mr. Chair. I'm also going to speak against the main part of the notice of motion, and I'm going to do that because of the dangers of the signal it sends on predetermination. I want to refer this council and those listening on live stream to tab 7, page 34 of our agenda today, the minutes of the meeting of council held on the 30th of July 2024, which we have already passed. I'll read out what was recommended there to council. For public consultation to be undertaken, council adopts the draft Donovan Park Master Plan Attachment 1 and draft Implementation Plan Attachment 6. Approves the review of the Donovan Park Reserve Management Plan 2012 two-step public notification process, beginning with step 1, which will occur 3rd of August to the 4th of September 2024. Supports initiating the process to consider the agriculture and events areas for land uses, including residential housing. We are already on track with our Donovan Park process. We have passed those minutes today. I am not prepared to be part of a council that puts through a notice of motion today that looks as though we have predetermined and made up our minds before we have done what we have actually, funnily enough, I think today is the 27th.
Yep, all day.
So we are in the midst of the 3rd of August to the 4th of September process. It's just something that smacks so definitely of predetermination and already made up minds to instruct the Chief Executive on a course of action, an expensive course of action, a course of action that is likely to have a bit of pushback from the Minister. but even more so, I shake my head that we have just today passed the recommendations for a process we have underway about Donovan Park. I'm sorry, but the main part of the notice of motion, I cannot agree with. The minor part of the notice of motion, on the housing density matter, the Chief Executive has indicated can be done. See no reason why it can't be done, given staff a reasonable time frame. But the main part of the notice of motion, I just am shaking my head at why this council would pass that notice of motion. Thank you.
Ringy.
Look, mine's about process, and if it's allowable, Chair, I'm going to ask process man, Councillor Ludlow. When would, obviously Council applies to revoke the reserve status, and if that's done, it then becomes resorts to what the district plan says it is that right? Yep. And then, so what stage, say Council does want to turn it into residential, when does the LUC, that land use capability thing, kick in to Council when it applies for the reclassification, or is it for the person who potentially buys the land and it's his problem? So just wondering where that where that hurdle kicks in.
Yep. So in two places. Firstly, Council in making the application would have to address that issue.
For the rezoning?
Yep, and then it would also be asked by the Minister of Conservation.
Oh,
it would be. It's a question that would be asked. It's how it's answered.
Yeah, okay.
It's not a barrier. It's a hurdle.
Yeah. Because I just saw them as two separate things: land use classification, capability, and the reserves status.
We would need to be asking that ourselves in looking to change the status of the reserve to whatever it was we were wanting to reclassify it, because that land use would be one of the questions asked.
Right at the initial application.
Yep, and then again, that question would be asked by the Minister.
Thank you. It's answered.
Tom.
Look, I think that the notice of motion, to a large extent, is an expression of impatience. Both of these matters, Donovan Park and housing intensity, are matters that I recall being raised very, very early on in this triennium. Here we are coming up to the third year, and we are kind of starting the process. And for that reason, I think it does require a bit of spur, frankly. I think if we simply kind of roll on as we have been, then I don't think we're ever going to get to any point. So I see this notice of motion against us providing a bit of spur to a process that seems to have been slower, much slower than it needed to be.
Thank you. Peter.
Yeah, thank you. Talking about land, there was an article in the Southland Times on July the 11th, 2016. Invercargill City Councillor says council should act on housing for the elderly. A week later, on the 18th of July, I got a letter of congratulations from Margaret Cook, convener of South Alive Housing Group. What have we done since then in those 8 years? Nothing. There's a definite shortage of housing for the elderly. This is an opportunity to free up some capital to build more housing for the elderly. At any one time of our 230 odd units, we have about 100 of our elderly on the waiting list. Some are waiting 2 years and over. Some of them are living in undesirable rental properties. Look, they deserve better. So I'm in favour of the motion on selling this land, or going forward to the idea of selling it and providing some more units for our elderly. Thank you, Mr. Chair.
Alex.
Thank you, Mr. Chair. Mine is a question a bit more around process and standing orders. For this paper and notice of motion to come forward and actually for us to have this discussion and pass it, would that not then be in a direct negative of the recommendations that we've just passed, like Councillor Soper said, that on for the public consultation to be undertaken and for the draft master plan and the draft implementation plan? And therefore, you may, for your notice of motion to go forward and overturn a previously made council decision, you should have had, I think it's about 6 council signatures required to overturn a decision. So I guess it's a question on process of standing orders as to whether or not it can even progress without those six signatures.
Sure.
Thank you, Mayor Clark. So the reason this is has not required the 6 signatures is it's not overturning any decision. It is simply, as Councillor Campbell has alluded to, speeding up the process that staff had earlier outlined. It is acknowledged that it is close to overturning, and it certainly can be read that way. But when looking at it and going through carefully all of the resolutions that have been passed by this council and the committees, it is not actually overturning anything. It is simply suggesting that the process be sped up and setting a time frame for certain events to be achieved. So that is why it was considered not to require the 6 additional signatures to meet standing orders to revoke a resolution.
Okay, thank you for that explanation.
Trish.
Is it possible to vote on one part of this motion?
Sorry?
Is it possible to vote on the separate points to this motion
Certainly.
rather than the whole motion?
Yes, can do that.
Thank you.
Yep. And Darren? Oh, sorry, Alan?
I was just going to ask you, Mayor, if you'd like to comment, actually reply to what Leslie said with what's already been in previous minutes.
Certainly.
As to why you're doing this now and why wouldn't you wait?
Yep.
So,
I
I
think
understand what Councillor Campbell's saying.
Yep.
I totally agree with him as well. It's been dragging on and on and on. I'd like to see things move along too, but I'm just wondering you could perhaps respond to what Leslie said.
happy to do that. And I've also got a question for Darren as well. I think it's a little bit of a difficult situation that you try and promote some action within our council, but then you're determined to be predetermined. We regularly go out to the community with a range of options sometimes, and we often put in, this is the council's preferred option. And I don't know why we can't do that. I'm happy to move this along, knowing what Darren has said, that I'll be predetermined. And if I'm predetermined, that's a sad indictment, but if that's the case, so be it. But somebody's got to kickstart this. It will drag its feet. We've dragged the housing issues that we've got for 20 years plus. And the other thing that worries me is the issue of which Peter raised, which is the issue of having a need for more elderly care. And finally, the issues made by senior politicians last week or the week before around capping rates for core work. And I think if we still want to be a council with some degree of excellence, and we've been financially diligent for decades, I think, and have done really well, we've got to have some reserves that allow us to work our way around what might be a rates cap, so we have other resources available to us. Revenue is more than just rates. It can be interest on bank loans, it can be costing for services that we provide, so dog licenses could go up. There's lots of ways of getting revenue, but I just think this is an important way, and it's interested that while councils might well raise the issue that I'm predetermined, it's really interesting in our long-term plan we've already put in money from the sale of Donovan Park as a future source of revenue. And if that's not predetermined, what is? But look, I'm happy to be guided. I won't be here 13 months from now, and so I'm quite happy.
you want to just, can you clarify that, please? Sorry, through you, Chair.
Well, we do have money.
You won't be hearing that.
Yeah, that inappropriate comment there, Councillor Ponga. What you sought was that we already have figures in our long-term plan that source income from the sale of the Donovan farm. That's my understanding.
Can you ask the Chief Executive to clarify
Michael?
that, please? Mr. Mayor?
Through yourself, Mayor, I'd just like to point of clarification in relation to that. Your long-term plan has a sale proceeds indicated in it in relation to disposal of properties. It's not specific in relation to how we obtain that. There was a aspect of how to calculate that, and there were reviews in relation to what land was put onto the park's land disposal, and that was used as an indication to audit. Should you need to deviate and find another land parcel from that perspective, that would be need to come back through council. So there is a target in relation to finding a saving, which probably brings me to my other point of clarification, is that this is already included in your long-term plan, as just been noted. Using it for other purposes and offsetting your rates is not an option because it's already been included into your forward plans.
But correct me if I'm wrong, but I thought the figures that were in the long-term plan were somewhere around about $20 million.
Through Chair, they are actually lower than that, slightly lower in relation to the total figures. I'm looking at my finance results, but
But if I
total
look,
sales, about 11 in total for property sales.
yeah, but if I look at the other parcels of land we've got, it's unrealistic to suggest to elected members that the $11 million that you've got in there is from some small parcels of land like the Bluff camping ground and other places that we might potentially sell. I mean, surely that's an indicator that we've got to get some money from Donovan. But that's okay. We don't want to be here all day arguing about that. Ria?
Thank you, Mr. Chair. On going through your notice of motion, I also don't support it as it is currently.
Yep.
I also am erring on the side of caution that what I say doesn't predetermine my decision on this. But what I can speak to is, as Councillor Ludlow said, that when we went to the Donovan Park Master Plan engagement meeting last Wednesday before, majority of the people that were there thought they were coming to have a discussion on this very thing.
Sure.
So it caused a bit of elements of confusion, and Darren did clarify the process that council should take in going through that process for Donovan Park. One of the things that was spoken on and had an understanding around some of the tables, that if the land Donovan Park did go through the process over a period of time, 18 months, 2 years, what have you, that they seem to think that the direct sales from Donovan Park will put back into the museum. When asked how they came to that determination, they said it was in the media, and they were concerned about that. Someone else at the table was very right, that said that any sale of Donovan Park under Parks and Reserves has to go back to that and cannot be used for any city projects. And I think that has to be really talked to, so that there's not a misconception in the public, as there was at some stages of that meeting, that the money that we sell Donovan Park will gets put away to the museum. I come along to the land use capacity and the NPS for productive land 2022 status, and the question I wanted to ask from our advisors is that it's come up in the information that this area of Donovan Park contains a New Zealand Archaeological Association site, that the exact location is not exactly known, but that may have to undertake, should we want to make significant changes in its status, a examination or assessment, an archaeological assessment would have to be taken. So already we're thinking about the money that it's going to cost us to get to the position of having that decision going through, but then we are also going to be having to think about the archaeological assessment and the cost of that involved. So I guess my question is, would that impact at all the fact that there's an archaeological significant site there, but we're not sure where it is, but we're going to have to investigate it at a cost?
Michael?
Through yourself, Mayor, yes, there will be a cost associated to doing an investigation of that nature, and that would be part of a process in relation to any future use or disposal. That won't necessarily be a limiting factor depending on the size and scale of that particular site and where it is, whether it's actually within the park not included under the agricultural events, or whether it is. So that would be part of the process to identify it, and even if it is, can it be ring fenced from that perspective? So that's part of the process we've got to go through.
Thank you.
While you're giving us advice, Michael, what does the Reserve Act say about resources that are sourced from the sale or disposal of reserve land or ex-reserve land?
Thank you. Through yourself, Mayor. Look, sales and proceeds from a reserve land, depending on the nature and status of that particular reserve land, and in the case of this one, it is recreation reserve. I'm just looking for a nod, but I'm pretty sure it is. If it's recreational reserve, it does need to be used for the purposes of that reserve across our future budgets. Not particularly to that site. It can be used across the council boundaries for recreational reserves, but it is ring fenced in relation to being used for future reserves, any proceeds.
So it could be used for parks activities. For argument's sake, it could be used for Queen's Park.
Reserve Park.
Yep. Okay, that's fine. Thank you. Grant?
Yeah, just a question around the current process. What's the timeline for the current process? Probably Darren's question for you, perhaps, or staff.
Consultation period finishes September 4th. Be a couple of weeks for that before it comes back to. Yeah, end of September. For hearings are held.
Yeah, and then what?
It's very hard to hear here.
Yep.
Apologies. So consultation goes till September 4th and the hearing's set down for 30th.
And so then what happens post that?
I couldn't predetermine an outcome, councillor.
Okay.
It depends on the decision.
So if
The decisions around the management plan, the management plan will be adopted in whatever form. But at the same time, what Mr Day talked about is there is also another process that council staff are working on that allows this matter to be consulted on directly. So there's no ifs and buts about it. People are very clear on what it is that's being consulted on. The concern that I was expressing beforehand is if we rush that.
Yeah.
There's confusion at the moment because there's so much consultation going on and general consultation fatigue. It doesn't help that you've had the master plan management plan process in there as well, and there's misunderstanding because of the timing of articles in media about the potential housing development process.
So if it was determined through the consultation process and hearing that the proposal to reclassify the land and then progress through to residential housing or whatever else.
So that's a separate process.
Okay, so what I'm trying to understand is...
How long will it take?
Well, the RMA...
It's the piece of string at this moment. It would be, and this is where I understand Mayor Clark's frustration, it would be 12 months.
Okay.
To run a safe one, and that's an estimation, to run a safe one that had, if you were looking at making the change, that had a better chance of passing the threshold with Minister.
Yeah, and so therefore the RMA that's under review, particularly in relation to productive land, currently, that potentially could shorten
this
that
process would happen first.
Yeah, but if that outcome
No, this
was...
process will happen before Parliament changes the rules.
Yeah.
Oh,
we
right,
have to
okay.
do
Okay.
within this current bracket. Yeah.
Because there's a few things that came up at conference last week that are landscape changes, but
And
they're not
housing
going to happen
density and
overnight.
amenity requirements.
Okay, so if this motion's supported, it does significantly shorten the time frame.
Oh, that it does, yes.
Steve?
Thanks, Chair. Yeah, I'm struggling to support the motion as it stands at the moment, but I really want to. And I echo that sense of impatience around this. I've mentioned before in a meeting that I think there are potentially some opportunities that we have missed in the consultation process around Donovan Park, and I personally have a really open mind around the future of it, including residential use. But just to echo Councillor Soper's comments, I guess, my concern sits around process and the statement that we make to our community around a predetermined decision as this consultation process is happening as we speak. So if there's opportunity for another consultation which really firms up what we're actually asking and the opportunities that sit in front of us, I've always been an advocate for this. I think we missed opportunity there, but as it stands at the moment right now in the thick of a consultation, my struggle is a statement we're making to our community about how we make decisions around this table.
That's a frustration for me, I guess.
Yeah,
is
absolutely.
that,
I hear
you know, this is often seen as me and trying to push staff along, but actually it was the staff, the park staff, who identified 2 years ago that Donovan Farm, along with 15 other parcels of land, should be open for disposal. And to date, 2 years later, we haven't disposed of any of them. So, there you go. Okay. Oh, sorry, Pania.
Sorry, just briefly, I also don't support the notion of motion as it stands, only because mainly when we went out for the long-term plan consultation, Invercargill residents were very clear that they didn't support the sale of the land and had other ideas. And also, I have to agree with Reverend Cook in regards to there is a number of land parcels within Invercargill, especially the ones down in front of Waihopo Runaka, and also support Councillor Soper in regards to pointing out that we've already just gone through the approval of minutes from our last council meeting in regards to Donovan. So, yeah, that's my position. And I know I don't get to vote, so kia ora.
Yep. So, just a quick comment to some of the things that I've heard. I know about Te Puawai, which is a very large development in South City. But again, that doesn't help developers who want to get stuff done. We've got to have the availability of land. It's no secret that we're currently working through a potential joint venture with SIT, because they also have those houses they're building down the road here, outside the Workmen's Club, for a year. But they can't sell those properties because there's not the land to sell them to. So we may have some opportunity for some of the land that we have to start that. But 4 years not enough. We need hundreds. And so I guess that was my initiative, to open up a large parcel of land, which would certainly help the revenue stream and also help with the aged care. So Tom, the last chance, and then I'll put the motion, which is probably a bit of a fait accompli, but I will put it.
Chair, I wonder, what, you know, as I hear people speak, I think there's a lot of unease about the fact that we mention a date, which therefore, although the reason for that is to try to hasten the process, but, you know, puts an artificial deadline without there being a whole lot of science behind that date.
Yep.
So I just wonder if you would consider modifying number 1 to by the earliest practicable date, rather than expressing, you know, a particular date.
Yep.
But that's the work that's already underway.
No, but I mean, I know it is, but it does seem to me that I think there are a number of people here who are, you know, impatient perhaps with the process and would like it done with the greatest possible haste. I think there is an unease about setting an artificial date. Yep. And I wonder whether, because I think you're right, it's pretty obvious which way it's going to go. If you leave it as it is, whether it would be feasible to change it to that by the earliest practicable date. In other words, express an expectation to management that they move with the greatest haste that they can, accepting that it's going to be within the rules of the game.
Yep. Well, I'm open to that, and I'll take Darren's advice in a minute on it. But again, the as fast as practical is an open-ended target that we cannot hold staff accountable to. And I guess we could be sitting here talking about this 12 months from now, one or the other. Sorry.
I think though it's a very clear statement to staff that we do ask them to move this forward, as quickly as practical.
Yep, I understand that. So I'll take Darren's advice in a minute. The other issue that we face is that we've already got two parcels of land that have been forwarded to the Minister's office, I understand, and the advice we got back from the Ministry was, while we normally process in a 3-month time frame, it's more likely to be a 9-month time frame because we have staffing issues. So we already have at the departmental end delays as well. And I was hoping that we could make sure that Donovan was the next one we send and not further down the track in the list, and that I would then write to the Minister and say, hey, this is a bit of a priority for us because it ticks off a whole lot of the objectives that the government is asking us to address. And whether that brings any influence or not, who would know? Maybe not. But I'm open, Darren, to you suggesting what is a more realistic time frame other than what's in what's the name?
You see, I think the writing to the Minister and stressing the importance is where the hint of, and that's polite Kiwi understatement, the hint of predetermination sits. But I'd have to defer to Ngāti Michael's over process of changing your notice of motion.
Yep.
I'm a little unsure whether it's your notice, but there was a notice here that we received, whether you're able to amend that. I'm RMA brain fogged out at the moment.
I think I was the seconder. I thought the seconder could move an amendment to a motion.
Normally, but this is a notice of motion, which is a little different.
Okay. Is it?
It's more a movement.
It's a formal.
May I just ask one further question? Before we hit the mark?
Through yourself, Mayor, before I defer to the other Michael on the other side, I just wanted to do two corrections that have gone through in relation. You will hear, and the Mayor alluded to it, we do have land in the sales process. There are two that are before the Minister, and sadly that is where we did get the indication there is a long wait time in relation to it. And in the long-term plan we did indicate that we would be starting that process post 1st July in relation to the land sales. So there are a number that are going through the process now. Two are lodged, and there's a few that Council's already signed off that we've got in the process. The other one is a clarification in relation to what we're hearing in relation to coming from RMA changes. I just want to highlight the focus is on L3, not on L2, so we won't be waiting to see what the legislation happens. We don't think that'll change the process. I'll probably hand to Michael in relation to notice of motion component.
Thank you. So understanding orders rule 28.4, once a notice of motion has been moved and seconded, no amendments may be made.
Very simple. So I'll move. Tom, are you seconding?
Yep.
Yeah. All those in favour? Sorry?
Okay, just wanted to ask one quick clarification question.
Sure.
If this motion moves through,
Yep.
do we then have to accompany that with our current consultation as a potential option? Because we're already out consulting on a particular
Separate
suite.
consultation. It has to be separate.
Yep.
But it's so disingenuous. We're saying, hey, look, yay, we're doing this fantastic thing, and here's our master plan. And then we're like, oh, but hold on, in the back door, we're also looking at this.
The potential of it is signalled in the master plan.
And is that
It's
enough?
just, it doesn't have a spotlight on it, but it sits there.
Oh, it just makes
We've
me nervous.
already started at a staff level that process for going out and consulting on that. The notice of motion seeks to accelerate that process.
You're right. You're
Should be broken into separate.
yes, I can do that. I can do that. Yes. So Alex, just in response to you, that's part of my frustration. We've done master plan. No, we've done management plan consultation. We've now done master plan consultation. That's the document there. It's massive. but we haven't really said too much about disposing of the land. It's sort of been there but not been there because we don't want to predetermine. And then after all that, we go out and sort of try and sell the land. I just think the whole process is flawed. But hey, that's what we've got to work with. That's what we've got to work with. So, Tom, you're a seconder, I take it. I'll put those motions that we've got.
Hang on.
Yes, I'll do them individually, which is what I... Sorry.
Can I just maybe suggest that, and I've stolen the idea from Trish, so I'll give her credit, that you give consideration to taking a vote on 4, that we receive a report from,
Yes.
the council receives a full report on our district plan, because I
Yeah.
think that informs us more fully. And then the other 2 motions are left on the table until our consultation process that's in flow is concluded.
It's not how notice of motion works.
No, I'm just trying to...
That's why it's a dangerous trigger to pull.
We're trying to find ways to support it.
Oh, yeah, no, but the first one is receiving the notice of motion. I mean, that's a formality. I don't care. I'm not going to lose sleep over it.
I think Michael Morris will probably tell us we can't leave 2 and 3 sitting on the table.
We can't.
No.
You'll have to vote it down.
No.
So here we go. We got. I'll put through motions 1 that we receive the notice of motion. All those in favour? Aye. Anybody opposed? Carried. And I'll put 2 and 3 together because they are linked. I'll put 2 and 3. All those in favour? Opposed?
No. Division.
Yep. All right. Called for a division, so we'll have that. So those in favour are Tom and myself at this stage. Alan and Peter. And Barry. Yep. So that's, and everybody else is opposed. Yep.
We should call a division.
Yeah. All
We
right.
don't want former Councillor Arnold back tapping us on again.
1, 2, 3, 4, 5, 6, 7, 8 opposed. So that.
You know the horses that are on the park?
So 2 and 3 are declined or lost, and the final one is the report from council staff on the level of intensive housing that we're entitled to have at this stage. So I'll put that as well. All those in favour? Anybody opposed? No, carried. Thank you. Yep, so councillors, just be mindful that I'm going to jump forward to 17 at the moment because 14, 15 and 16, 15 and 16 will have some discussion points and we need to have staff available for tab number 17, so just wanted the adoption of the regional council climate change strategy for Murray and Southland. A mover and a seconder to that. Do we have people wanting to talk to that?
Councillor Campbell's moving and I'll second.
Yep, and we've got staff to talk to it. Jonathan and team.
Thank you. So, through you, Chair, in interest of expediency, I'll take the report as read. Would draw Council's attention to one minor change, which is we've noticed Mr. Rod Carr has been given one more D than his name requires. That's in the process of being changed. Also, it pains to point out that although it's my name at the top of the report, minds immeasurably superior to mine have been working for far harder and far longer on it. To that end, Councillor Morrison has very kindly offered to speak, having spoken recently at Gore District Council when they adopted a strategy.
Yeah, thank you. Thank you, Mr. Chair. Just a few, probably 3 points I'd offer in the interest of time expediency. The first is, first of all, to acknowledge and thank ICC for their support to the work of the Regional Climate Change Working Group. And I guess it would be my aspiration that that level of excellent and valued support continues into the future. Perhaps the second point is that the Phase 1 Regional Climate Change Strategy, which you are currently considering, it's been tested through the public consultation process, and I believe it is a stronger document as a result of being tested through that consultation process. The third point would be that the strategy now provides a very sound foundation to undertake further analysis of the regional climate change activities and investments needed. The core elements of this Phase 1 strategy are the principles which guide or provide guidance on how collectively and collaboratively we intend to continue to work together into the future, and the aspirations of the other core element, which signal the outcomes to which we aspire to working towards together. What remains to be analysed in the Phase 2 work that has already started, but remains to, a lot of work yet remains to be achieved on that front, is to understand how we will go about delivering on those aspirations. And it's within that Phase 2 work that we'll consider hazards, risks, opportunities, likely costs of action or investment, as well as the likely costs of inaction on climate change issues. But I'm happy to take questions or respond to any concerns that councillors may hold.
Thanks for that. Questions, councillors?
Happy you're taking the lead.
Yeah, so Rangi. Yep.
Look, I just read the other day, something to do, new hobby, that China consumes 1 trillion tonnes of coal a year. How do we lobby against that? I mean, obviously 1 trillion tonnes, makes everything we do sort of reasonably insignificant, but I mean, obviously we've got to do our bit, but like we're sitting here doing this much, and over here is this. So what do we do?
Yeah, through you, Mr. Chair. It's interesting to reflect on the carbon emissions profile per head of population that New Zealand sits well above per head of population emissions from China. There is one strong idea that actually it's always darkest before the dawn, or in some cases it's going to get worse before it gets better, and then sometimes we might actually have to burn or expend fossil fuels in a greater amount in order to break free of the hold that fossil fuels holds on our global economy.
So there's none left?
I wouldn't say there's none left. I mean, we didn't abandon the Stone Age because we ran out of stones. We can move on from the fossil fuel age because of other better technology that's available to us. I guess it's also incumbent upon us, given our obligations under international agreements around this, that we probably do have both a moral, a geopolitical and economic imperative to act on this.
Okay, and the other last question was regarding the coal, is importing coal rather than using our own native coal. Does that make sense?
It makes sense if you see it as a short-term stopgap measure as transition to some better outcome in the future.
Okay.
You, Grant.
Yeah, on page 3 of the strategy, it's noted that our emissions have dropped by 14.8% since 2018. I'm interested to know what we've done to get that reduction. Yeah,
so that data is drawn from a report by Great South, who on an annual basis update the regional emissions inventory. A big part of that has been a reduction in livestock and the associated reduction in methane emissions for the region, so that's an interesting one, as well as some investment in technology that helps decarbonise some of our industry, so converting coal boilers to more modern boilers in some of our industrial installations. I suspect there's a range of other more minor initiatives around the region that have also contributed as people transition to things like electric cars or install solar panels on housing and things like that.
I mean, it's quite a big drop, so, the odd electric car, which, is it environmentally friendly? Well, there's debate on that as well. Livestock reductions, can you elaborate on that, please?
Yeah, I think across our region we have seen a decline in the total number of livestock since 2018. Less head of cows, less head of sheep, and that's currently as part of the counted in the regional emissions inventory. And so that reduction has a natural accompanying reduction in overall emissions, given that biogenic methane is currently counted as part of that regional contribution.
And the last question, so is all the sequestration with all of our forests, given in mind we've got one of the biggest rainforests in our jurisdiction, in Australasia, if not, you know, most, that's all taken into account? So we've got a net number, have we, or are we just a gross number on emissions as opposed to sequestration?
My understanding is that where possible and where we're allowed to account for sequestration through forestry, we are doing so. I understand that there still remains some constraints on what can and can't be counted in terms of what was existing as established forestry prior to 1990, when the emissions trading scheme suggests that you can start claiming from. So my understanding there, and I don't claim to be an expert at all on this, I'll defer probably in the first instance to our Great South colleagues, but my understanding is that if it's established forestry that was in place before 1990, then we can't count it currently as part of our sequestration contribution.
But doesn't that highlight the issue where it's sequestered carbon before and after 1990, so some legislative rule just, you know, seems ridiculous, doesn't it?
Well, I guess if we want to start measuring, we have to draw a baseline somewhere, and currently with national legislation, that's where they've chosen to draw it.
But it's still sequestering carbon.
Tom?
I mean, just, I will ask a question in a second, but just commenting on what Grant just said. If you look at the charts, there's about 300,000 tonnes a year additional sequestration since 2018 through now, so it's very significant through forestry. But the comment I was going to make, Chair, was that obviously this report, the strategy deals with both mitigation and adaptation. As we went through the consultation process, and as we met with quite a number of people who came and spoke personally, I think there were two things that people were unanimous on. The first being that the councils should work as a single group, that there should be a single strategy for Southland. And the second one was about the importance of adaptation. So everybody accepted that the climate changed. Not everybody would agree that it was changing because of carbon dioxide, but certainly accepted that the climate was changing and that, you know, that there was likely to be, you know, greater level of storms and so forth, and therefore that the councils needed to work together on adaptation. I think the thing I would say, without trying to reduce the significance of mitigation, in my view, the vast majority of work by councils, I think probably 95% of the work by councils going forward is going to be in the area of adaptation rather than mitigation, because there's actually not an awful lot that we can do directly in mitigation. So adaptation is going to be the, you know, the key piece of work, and certainly in terms of spending, as we look at budgets going forward, you know, that's probably going to be 99% on adaptation rather than in mitigation. So there was that unanimity.
Yep.
From people. Essentially we work together, essentially we work on adaptation, not so sure about mitigation.
Yep.
But again, it's not really the core focus of the councils anyway.
Yep.
Because we don't emit that much.
Yep. And I would just reflect that that would be my view as well, that we need to go down the adaptation line while we have, and this is a monumental day that I'm agreeing with Rangi, while China's doing a trillion tonnes of coal, and Brazil, US, China and India are the big players and the big polluters, that whatever we do, we're just wasting our time. And so we just got to adapt to an ever-changing climate, and I think that's the way forward. Evelyn.
Kia ora. Should I be allowed to move? I would have moved this motion. However, as I'm not allowed to, all I will do is speak positively to it. I think that the fact that all the organisations got together and worked on this is really important. I think that the message that we as councils, as members of the community need to be sending is actually that whilst there are macro issues here, there are also micro issues. There are things that we can do as individuals, there are things that we can do as communities that will actually make a difference. So I would like to actually recommend to my fellow table members that we do adopt this. And I wish to thank Councillor Morrison for the fact that he provided me with a copy yesterday on paper so I could actually read it properly. But I think it is actually one of the important issues that is before us as a community, because it will affect the planning decisions that we make. We know, for example, what impact climate change potentially is going to have on where our airport is located. There will be other infrastructure items that we will have to reconsider where the location is, given what we see coming at us over the next 50 years. Sadly, I won't be here to see it, but I think it's coming. But I would like to urge us as a table to endorse this very cooperatively developed document and adopt also the strategies going forward and continue to lend our energy to this process, because I think this is part of what we are supposed to be doing as members of this table on behalf of the rest of the citizens, is having a long vision, not just the vision for the term that we're here for. Kia ora.
Thank you. All right, I'll put that motion in. Tom and Leslie, I understand. Mover and seconder.
And if I can just very, very quickly, as the seconder and Tom's colleague on the group, I just want to say, look, there has been no doubt at all this has been a major example of how really productive it can be for the four councils, Te Ao Marama and Great South, to work together on a highly significant project that is going to outlast all of us. What I'm really proud about is that we have worked so well together, that we have got to the point where we are bringing such a very substantial document back and saying we're now at the point where the regional framework for action, which is the most important next step for us, can actually happen. That's the important thing. We've got the principles in place, we've got the commitment to working together and continuing to work together. We've got the aspirations that we have discussed over all the meetings Tom and I have attended, and that's obviously been agreed by all councils and the two other partners, and we're at the point where that framework of action is just the next absolutely necessary step if we're serious about addressing these issues for the future. And I believe we are around this table, so obviously I seconded the motion because I'm very keen that we show the commitment to this, as the councils who have voted ahead of us have already done.
Yep. So I'll put that adoption of that strategy. All those in favour?
Aye.
Anybody opposed? No? Thank you very much.
Chair, just before we move on, I think it's appropriate to thank the chair of that group, Phil, who's not only come here today but has done an enormous amount of work on this. I mean, you know, I don't know what he expected when he took it on, but I guarantee you've probably done 10 times as much in terms of hours as he ever expected. So, and has been a tremendous leader actually in the process to get it to this point. So I think we should thank him for that.
Yep. Thank you. Right, we've got a 10-minute break now. A very short 10-minute break, which we're required to have. We're back live? We're back live. All right, welcome back. So we're on to 14, 15 and 16, which are a cluster of items. 14 is being left on the table because it fits in with the workshop that we've got next week before infrastructure. And that meeting was meant to be today but has been moved. So we move on to 15, which is a Bluffwater Consenting Program, multi-criteria analysis. We have 4 recommendations there. I'm going to add a recommendation, so I've already signalled that. And it's a recommendation 5, which I'll ask for support of shortly. And it reads that option 1A be added to the shortlist for further consideration and BPO assessment. The rationale for that added criteria is that as we work our way through board books, and the utility report refers to benchmarking. So it's very important that, in my view, that we have 1A sitting in there as a benchmark against which we operate everything else. It was raised at the last meeting that mana whenua were opposed to that, and I still acknowledge that. But that should not be a veto right at the early stage of the assessment. It should be a consideration that the process takes into account as we move forward. And we heard Andrew, who was the planning consultant that we used last time, say to us that given the criteria we're about to consider next week, which includes percentage weightings for different criteria, that we may end up coming back when we look at the affordability issue, which is rated at this stage at 40%, coming back closer to one of the status quo options with some amendments. So I will put that subject to that being approved by the group. So we have, do I need a second for that? Yep, call for a sec.
Before that,
Certainly.
option 1A is still the option where we have the tag that says the condition and remaining life of the existing 50-metre Fauveau Street outfall may not match the life of a new consent.
Correct.
I still maintain that there is no logic in putting 1A in our viable options when we have a clear statement that the existing outfall is not going to match the life of the new consent.
But the cost of replacing a 50-metre pipe, I suspect, is considerably less than the range of costs that are put before us for the other options, the other 4 options we have, that range from 5 million to 27 million. So, hear your reservation.
It's just,
That's okay.
it's the worst status quo option that could possibly be added back in when we know that that existing pipe is not going to do the job for the life of a new consent.
Yeah, but that doesn't mean you can't replace it. I think it's like saying that we've got a treatment plant that we know that we're going to have to upgrade. It's still a cost going forward. It doesn't have to be a cost up front. It might be that 5 or 10 years down the track we have to replace the pipe or repair it. Tom?
I think the reason, or the point that Councillor Soper has made is the very reason why it should actually go to the next stage of assessment. Because if we consider it as being a kind of fallback benchmark option, then we need to understand the full cost of that option.
Yep.
And that'll only be determined if we take it through to the next stage and it goes through the same level of robust analysis as the other 4 options are. So I think rather than a reason for not taking it through to the next stage, it actually is a reason for taking it through to the next stage.
Sure.
The other thing I would point out is that 1F also, and I think 1G, also retain the pipe. So the question about whether you need to repair the pipe at some future date you know, an assessment of that and an assessment of what that might cost, and therefore on an NPV basis, how it should be judged, is best done by taking it through to that next stage assessment.
Okay. So I take it you'll second the motion to?
Yes,
Thank you. Rangi.
This is amazing, sitting here listening to people considering the status quo option. It's almost like we're the council in bedrock, you know, discussing the most crudest way to do something, considering that the RMA, as in that lead-in paragraph to the report states, we must put forward, you know, the alternative options and everything in good spirit. Considering we put $7.5 million aside for this, used to be 15, but you can understand now why New Zealand is suffering from poor three-water infrastructures, when here we are trying to take the cheapest possible option on such a critical environmental thing, and yet we're firing ahead, and I'm going to have to say this, with $19 million extra for a museum. So it just doesn't make sense that we are just doing the cheapskate one here. Sorry, and it's not a benchmark. Rubbish. This is serious stuff, and we need to do better than we're doing now. And to consider the status quo is an insult, in my view.
Yep, welcome to that opinion. Grant.
Yeah, just to clarify, so on page 81 of board books, or 1 of 9 of the Stantec report, that talks about 1A, but it's subject to continual acceptance of the currently consent mixing zone size of 100 metres option does not fail any other fraud criteria. So it's capturing the fact that it's still got to be tested whether that, as part of 1A being put forward, that there's still a fatal fraud test that it has to pass.
Page 98 has got exactly the condition I read out against 1A.
So
Page 81 and page 98
so why are they different?
are phrased differently. I would like to, and I point out that what is on page 98 was what was in our original papers.
That's
what is
right.
on page 81 has been changed.
That's right, yeah.
But page 98 is left in place to make it clear that we haven't got an outfall that's going to match the life of the new consent.
Yeah, but the point I'm trying to make is that that's been addressed by adding in the fact that it must pass that test of the fatal fraud criteria. and like I'm similar, I think we need a baseline for you know, determining what the best outcome for this process is, and the baseline is what we've got currently. If it meets the criteria, it's a minimum viable standard, and then everything else becomes a discussion and a decision around how you improve the key metrics, which are water quality, community wellbeing and cultural, and with the additional cost.
Evelyn.
Kia ora. So I have not been engaged in this process, other people are. But there are a couple of things that I am quite an expert on, and this is one of them. Whilst it says culturally here, it was not Te Ao Marama alone that vetoed these objects. As I understand it, this was an agreement of the parties around the table. In order for it to be seen as fatally flawed, people had to agree. That's the first thing. Saying cultural and making it sound like it's willy-washy, woofy sort of new age stuff is doing this a disservice. This is based on Māori environmental knowledge and science. In other words, the shellfish that are in the range of this outfall are filter feeders. Filter feeders retain toxins, whatever they take out of the water, in their hua, in the guts of them, which is, if you like shellfish, is the tastiest bits. So we're talking about power, we're talking about all those sorts of things. Very prized around the back of Bluff. We have a mataitai there. This is a little bit more than cultural. This is highly significant, long-term, food-sustaining fisheries for our families. In times of poverty, which we are in now, there are many of our families that depend on the food that they obtain from this area. To just brush it aside as cultural and not necessarily of that significance, it's given weight in the RMA for a reason. And I think I would like to hope that we have moved on as a society to where we actually acknowledge that Indigenous peoples have scientific knowledge. They knew why they did not put their tutai and their mimi into the rivers and the seas and the places where they gathered food. We have seaweeds that we can no longer gather because they have been so polluted by the discharges that we have allowed to happen as a society, not picking on this council alone. This is this council's opportunity to make right something that we have been doing to the area in the marine and coastal environment at the back of Motupohui or Te Taurapa or Te Wakaoraki. It is a place of extreme significance to all of us, and really to just sort of say that we vetoed is actually doing the whole process that all the team went through an injustice, but particularly to dismiss cultural as being of lesser value because its Māori knowledge is actually disrespecting the science that underlies why we have these particular traditional practices. Thank you.
So I have a series of questions for you, Evelyn, so you can help me so I understand. The Ngāi Settlement Act is 1998.
It was, yes.
Correct. The current consent was issued 2 years later in 2000.
The consenting process was 1999, the decision was 2000.
Yep. At that time, the consent was for the pipe to go 100 metres off the coast, and it was iwi's suggestion of 50 metres that brought it closer.
I'm given to understand that that was not necessarily the accepted agreement and consensus of everybody, but that was what I think was agreed to during the consenting process. But I wasn't here then, so I cannot comment.
Okay. The coastal plan, which Councillor Pottinger has raised with me before, is set in 2013. So, given your statement that...
No, I haven't raised that, sorry.
Sorry?
I haven't raised that with you.
Yes, you have. You emailed me about that.
No.
Yes, you did. So I'm not going to argue about it. I've got the email sitting in front of me. So, raised the coastal plan as being a significant document that needs to be considered, 2013. So we are now 11 years post that coastal plan and 25 or 6 or 7 years post the Settlement Act. It's my understanding from Environment Southland, and I have checked, that iwi at no stage has raised any concerns about that outlet from Bluff. You want to confirm that?
It's kura matua. We are currently just going through a fast track application to bypass the normal consenting process that iwi would be submitting to. So we actually haven't had the opportunity to submit to this consent. What we might submit to this consent is something that needs to be discussed by the appropriate parties at the appropriate time. What we are talking about is what we as a council are proposing to do. What I'm giving you the understanding of is that 2013 or 2015 for the coastal plan doesn't make the coastal plan go away. The coastal plan is currently under review. So during that review process, all these things will be taken into consideration, but the matatai is post-2015 and so is not indicated in there. It is definitely post-1999, and with all due respect, we've all grown up a lot in our knowledge and understanding in our processes since 1999. This council not accepted. So for us to be saying what was okay then with the knowledge that we have now is actually not true. We're all trying to do better. And we have some definite indicators of what doing better looks like, including the health and well-being of our waters. This isn't mana o te wai because mana o te wai reflects freshwater. This is Te Takotai Moana, this is our ocean and the food and the processes that we undergo using our sea coast.
So you raised an issue that local Indigenous people have knowledge about the impact of such discharges on, I think you said shellfish, within the outlet and within the coastal area around. So, assuming what I have in front of me is that's never been raised with Environment Southland, I know that because I've checked. And when I asked Environment Southland, have you had any complaints from iwi? The answer is no. Is there any research or any scientific evidence that a discharge pipe out of Bluff would be impacting on Pawa or Taiaroa, which has been suggested? And the answer is no. So on one breath, there is no scientific evidence or any research being done, but you say you have local knowledge, and my challenge to you is, it's all very well to say that, but if you've had that knowledge and you haven't complained to the regulator going forward that it's been a problem, then that doesn't sit well with me, I guess.
So, with local knowledge, knowing that the cities, the Bluff area's outfall is where it is, the local people don't go and take food there. They know because they have local knowledge. We cannot speak to what has been the experience of people who don't know, who think that the paua there are amazingly plentiful and fat. The other thing is that we also don't know what the changing tides and currents and weather events is doing either to the left or the right of the outfall, which means what goes out into Araakiwa, what comes into the coast of Oreti, where the tohiroa are. We don't know that yet because we haven't done the research, but it is something that we are discussing. For I can't speak for what Environment Southland have told you, but it might depend on which part of Environment Southland you speak to.
Tom?
Yeah, I think we're getting ahead of yourself, actually, Mr. Mayor. I mean, the only thing that this moves is that 1A should be considered as part of the next stage by the expert panel. We are not proposing that we use 1A. We're only proposing that it goes to the next stage of assessment, and I think, therefore I think we're getting ahead of ourselves, and I would, urge that we move the matter and, because otherwise all we're doing is just debating what we'll probably debate in the workshop, and then we'll debate in September when the whole thing comes back.
Okay, accept that.
Councillor Campbell, were you proposing a closure motion?
Yes, I am.
Yep. Okay.
And that requires the chair to put the motion.
I'll put the motion that we have no further debate on that, and we just move towards the...
I had my hand up before the closure motion actually got asked for, and I believe others did.
Well, I've got the motion, and I'll let people vote on that. All those in favour that we close?
I don't think that a closure motion can be accepted when there were obviously people in the room with their hands up.
And also I have a point of order that we take on tape with Councillor Campbell and our other good friend over here. What was that about? Was that about that you have to leave?
Councillor, just remind you, if you want to raise a point of order, you need to quote the section of standing orders which you're raising it under. You just can't start injecting into conversations by saying point of order.
my inference was that we're forcing a vote because some person has to leave very shortly.
No, well, that may very well be the case, but what
Well, that
the
may be the
Deputy
case.
Mayor said was that he felt that we were getting too far into the debate, that Evelyn had raised some issues and that we're getting too far down the debate instead of just putting the motions, which was 1A, should be added to the shortlist.
And I'm objecting to a closure motion where there were councillors who had their hands raised to speak before the closure motions was
Can we get a ruling on that, please?
I'm getting that. Okay, so yes, I accept that Leslie and Tanya can speak, so Leslie.
Thank you. So I am going to speak again against including one of the options that is listed as fatally flawed when we clearly have 1F and 1G, neither of which are listed as fatally flawed, as options that we have got on the shortlist. If you look at 1F and 1G, 1F and 1G, I'll read them out. So,
What
1F,
page are you looking at?
status quo, page 98, page 98.
Yeah, thank you.
1F, status quo 1A and surface flow wetland. Status quo treatment and 50 metre outfall, but with surface flow wetland before the outfall. New option may provide land contact. 1G on page 99, status quo 1A and land contact other than a surface flow wetland. Status quo treatment and 50 metre outfall with land contact added before outfall. New option. And then in the comments, e.g. rock passage, trench before marine outfall discharge, may provide land contact, could meet requirements of cultural effects assessment, etc., etc. We have 1F and 1G already included. Why are we trying to put in the fatally flawed 1A? That is my question. It is just not common sense when we already have two options in there that actually include the status quo with some new options, which, as Councillor Pottinger has said, actually mean that we're moving with the times and accepting that the status quo of the 1990s is old hat and that we should actually be doing better because that's our obligation as councillors. And here we've got, with no one is objecting to 1F and 1G being options we consider and being costed as options we consider. But to put 1A, which is clearly labelled in our documents as fatally flawed, just for me sits entirely opposite what this council is here to do with our wastewater treatment in our future. If we're talking about water done well, then let's actually show that we're seriously considering some options that are talking about water done well, not saying we're putting back the status quo from all those years ago just for the fun of it. We've already had an expert panel consider 1A and come down and say 1F and 1G should be there as options we consider. We're now saying, no, we'll overrule this because we want the ordinary old status quo to be back in there. I'm sorry, it just does not sit well with me, particularly when you've got 1F and 1G already in as options.
Yep. Yeah. What? Pania.
I also oppose the status quo, the 1A, and Councillor Soper again has articulated a compelling rationale for that decision. But also I want to note that systems designed to prevent contamination can fail. and resultant contamination of the coastal marine area, and this is evident in parts of the Bluff shoreline, regardless of what you think. As a local, we know not to eat the cockles, and I do know from people that have now new residents have eaten those cockles and ended up with diarrhoea. We know not to touch the power on the back in certain areas because of the same result. So also I want to raise that wastewater was raised at a number of times at the LG conference held in Wellington last week. It was clearly noted that discharge to ocean for some areas was a practice, and this is no longer acceptable, and they are quite aware of that. Even our Ngāi Tahu Kaiwhakahaere, Justin Tipa, made it clear that as an iwi, we do not support councils discharging wastewater, human sewage, to our ocean. So this decision isn't made clearly, isn't actually made easily for us, and it's carefully, things that we have to consider of environmental protection, public health, and well-being for future generations. So damaging our food source is not okay. So, and this, and I'm not the only person. It's a shame that, I'd be really interested when this goes to the Bluff Community Board, because there was a huge discussion regarding this matter. Kia ora.
Okay, thank you. No, Peter, you didn't have your hand up beforehand, I'm sorry. So, I'll put recommendations 1 through 4, which are the original ones that we've got to us, which are all about receiving and endorsing. And then I'll put the controversial 1A as a separate exercise. So all those, oh sorry, Tom, did you recommend 1 through 4 as well?
Yes.
You did. Okay, so I'll put that vote. All those in favour of 1 through 4?
Aye.
Anybody opposed? Carried. On the issue of number 5, which is to introduce 1A as the benchmark, I guess, for want of a better words.
Call for a division here.
Yep, certainly. Happy to have a division. So those that are in favour of 1A being added to the shortlist for further consideration and BPO assessment, which is coming, all those in favour, show their hands. 1, 2, 3, 4, 5, 6, and 7. Sorry, and Barry, that's 7. That's I'll do the negative as well. Those opposed? 1, 2, 3, 4, 5, 6. The motion is carried. Thank you. Moving on now to whatever the next one is. Okay. So we've got the next item, which is tab 16, which is the minutes of the Infrastructure and Projects Committee meeting held on the 6th of August, noting the current changes we've just authorised. So we'd like to move that.
Yeah, I can do that.
Grant, thank you. A seconder. Darren, thank you. Any discussion on those? All those in favour?
Aye.
Carried. Christmas decorations, 2024.
Oh, the Minister of
Russell,
Everything.
the king of decorations.
Who's Santa Claus?
Oh, sorry, the minutes of the, sorry, I was, yeah,
Yep.
sorry, I was going to talk to the CCTV.
Oh, sorry, yes, you're right, Russell. Yep,
Okay.
happy for that.
Right, look, there's some language here that is totally foreign to me, and I'd like someone to explain it. So, it's CCTV project, and it's the first paragraph in response to a question. Can someone please explain that? I mean, I've been doing this for 45 years, and I just thought this is baffling me, and I just thought I need someone to explain it.
What page are you on, sorry?
Oh, it's the first paragraph in 12. It's in the minutes of the infrastructure meeting, and it's item 12.
Okay, cool.
Page 7 of 9.
So it's 134 deliverance.
So, page 134.
Thanks very much.
Is that you, Aaron?
So, sorry, can I just clarify exactly which paragraph of that?
The very first paragraph, right after your name's mentioned and Richard Hutton's mentioned.
Is that the question around the breakdown and then the bidding process, that paragraph?
Yeah, that one.
Yeah, so that was at the time that the paper was provided. We were still in a tender process, which meant that we provided high-level information at the meeting, but we didn't provide a comprehensive breakdown of costs. And for that matter, we still probably wouldn't provide, and I'd need to take legal advice from Andrew, a full breakdown of the components of the winning tender from a commercial and confidence perspective. We usually try to make sure that we group those costs up to a higher level when we're providing them in a public report.
No, but you've already committed to online storage of data, and can you please explain that when you haven't looked at the other options?
No, I can't advise that. I'm not the appropriate staff member to ask. We had Richard Hutton at the meeting to talk through those elements. It's not my area.
And I can contribute to that. My recollection was Richard's advice was that the way forward with most organisations was to have that storage in the cloud from memory, using my lay terms, as opposed to storing in other methods. Okay, Russell, the floor is yours on decorations.
Thanks, Mr. Mayor. I take my paper as read, and I thought, well, I'd bring one of the more exciting elements in your agenda near the end of it. And I guess I bring this paper from quite a wide perspective of our council staff, because for the wider team, there are quite a few moving elements of Sanders Little's helpers that actually put together all the pieces that we do have at Christmas time. And the real purpose of this paper is to make sure that we align our expectations, or the expectations that we're proposing actually meet what the expectations of councillors are. And I guess it's quite important for me to point out that I'm actually bringing this in August, not November, so I think it's a great opportunity that if we're not actually heading in the right place, we do have a little bit of time this time to modify it if there are things. And I'm not sure the recommendations are correct on the screen at the moment, but I'm happy to take questions.
We are correcting that now. Thank you, Mr. Pearson.
I take it you'll be doing, Russell, I take it you'll be doing the paper that's in public excluded as well?
That's correct, sir.
No, not contributing.
Yeah, no, that's not.
No, it's all right. That's cool. All right, a mover and a seconder. Thank you, Trish and Darren. Any discussion about the plan for 2024? Ria.
Thank you, Mr. Chair. Russell, I did note that you were here a lot earlier than what you were last time, and the council was accused of being the Christmas Grinch on its decorations. I'm looking at your future strategy and through here, and in reflection, there are other types of visual decorations that the public liked, like down on East Street, for instance, last year. Is there, I guess what I'm trying to figure out is, our stock we've got currently obviously is not going to be fit for purpose for too much longer. We're resourcing and relying heavily on PowerNet to help us with the load of things. Is there other opportunities that you think that this council should also be including?
Sorry, I'm just going to clarify. We've got two papers today. One is around what's happening this Christmas 2024 with essentially the existing decorations that we have plus a little bit extra. The future strategy conversation is a separate conversation under a separate paper. Sorry, just to make sure, because Russell's not in charge of the strategy.
Yep, that's what I was alluding to before. Yep. Any other discussion around that? Oh, sorry, Grant.
Yeah, just with respect to the flags and Bluff, the community board raised the sort of challenges for that in Bluff, and there was discussion from within that committee about putting up some alternatives, and a local supplier sort of came forward around maybe putting up some more hardened Christmas decorations. Is there any opportunity to sort of test that for the Bluff community this year?
Mr Chair, I think in Bluff we might change a couple of the banner arms to a different style to see if that actually works, because the banners are pretty effective. If you put something up in Bluff, as we have in the past, that's more solid, they still tend to get blown to bits, and they take a fair bit of toll on the pole, so you've got to find something that actually won't get ripped. Last year we had 2 series of flags, the second series were brand new and they came away in tatters as well, so we're going to want to try 3 or 4 poles where we change the way we connect them to the pole to see whether that actually helps us for the future.
Evelyn, oh sorry. Evelyn?
Look, apart from the fact that I'm interested in the historic local who was changed, I'm assuming that's a locale, as we can't go there anymore because it's under construction. Is that right? Reconstruction? One historic local?
Oh, location, yes, it's the...
It's locale with an E? Yeah? Yeah. Okay. So, leaving that aside, I was thinking that we are still talking about this as if council is responsible for doing everything. And I think, isn't this time that we actually looked at other places in the world where they actually encourage the businesses to actually do decorations themselves? So if I think of the UK, where all the significant stores have absolutely fabulous decorations that complement what goes on in the street, we're still thinking like the city has to do everything for everybody. And I'm heartened to see that the shimmers are coming back, because I loved the shimmers. They were visible much earlier in the day, and to encourage those sorts of things, and I do understand that that is also part of the strategy conversation. But shouldn't we be sending a message that festive lights are everybody's responsibility because we all enjoy them, and how do we actually make it much less dependent on PowerNet putting their cherry pickers out and having things that are quite affected by weather up so high. But that's my message. I will have something to say about the rest of it at a future time.
Thank you. All right. We've got a mover and a seconder. All those in favour?
Aye.
Anybody opposed? Carried. Elected and appointed members attendance register, which is me. Yeah, thank you, Darren. Seconder, Alex, thank you. Any discussion around the report? Yes, Ria.
Just really quick, Mr. Mayor, I noted that some of my attendances recorded on the spreadsheet printout had the keys of AVQ in committees that I'm a member of. So, last time it happened as well, and I was told it would be corrected. So the question is, am I not now a member at Risk and Insurance? Am I not now a member at Finance and Projects?
No, it's AVQ means that you attended by Zoom. AVQ is attendance by Zoom, and it counts as quorum.
Oh, audio-visual quorum.
AVQ.
So that means you zoomed in, but you
right, thank you.
You were there.
Yeah.
Having a moment.
You were there having a moment.
Thank you for clarifying that.
Yep. Any further discussion about those? No? All those in favour of the report being accepted?
Aye.
Carried. Chief Executive's Management Report, Michael.
Yeah, thank you through yourself, Chair. It's an interesting report for me to be presenting to you, given I was not actually around for most of the report that has been written.
Excellent. That makes it easier.
Make it awfully challenging, and the person that was acting is not able to be here today to actually present to you as well. But what I would like to highlight to you is a couple of things. I won't go through the whole report. I will take it as read. But I would like to highlight the work that was done in relation to the CrowdStrike and our team. They managed to get our services up in extremely fast fashion across our whole network, which was a full credit to the team. I'd like to just acknowledge them in relation to that. That also had an impact in relation to our core infrastructure services, which in reality had no effect on our customers, and that was important in relation to our ongoing service. And I think I've already expressed my gratitude to the organisation in relation to how they operated and worked into the hours to achieve that outcome, but I'd just like to highlight that to Council. The other items on there, you can see there's a number of updates in relation to what's going on in relation to the consenting and environment space. I can't have sadly the consenting person go through it for you, but I would like to highlight it is an ever-changing space at the moment. They are working in a landscape that government is proposing and putting through new legislation, and they are spending a lot of time actually digesting into that and understanding what that means. It is a focus area for the current government, and we're aware of that, and we are working through that legislation as it comes through and understanding what that means for us. You will note on page 177, I think it is, there is information in there in relation to the housing needs assessment. So I think if Council hasn't read that, I would draw your attention to making sure you have read that. It is highlighting some of the residential lot sizes, and also in relation to the different types of sizes. It's only one piece of information in relation to housing, but I think it's important on previous discussions. I'll take the rest as read. I do have the rest of the staff here to be able to explain that to you. I would say, if you're going to ask me a question in relation to city and regional deals, based on the previous the discussion from last week, we are still waiting to see who those entities are that was discussed at that particular time. So I do not have an update for you at this point.
Okay. Tom.
Michael, I noticed the South Island Kia National Rugby League proposal, and it's talked about with some enthusiasm, I got to say, in the report. I mean, when I read it, I thought at a time when we're cutting back support for all sorts of other local things, why would we support something that was going to be based in Christchurch? You know, and I don't know how much money is involved in it. I know that it's implied that, you know, they may bring a game down to Rugby Park. I think that's what it says. But again, just, you know, I guess saying the same thing again, we're cutting back in support for a whole lot of local things. Why would we support something in Christchurch?
Yep, I can answer that, Tom, because I sent away the letter of support after Rex approached me. And so it's not a monetary support as such. It's just saying that we support the concept of it being a South Island franchise, as opposed to Warriors being a bit more North Island focused, and that we do have a ground that's available if they want to give us a game. It seems like it's one game every second season, which is a little bit like we get with the Highlanders. But other than making Rugby Park available, that's the only commitment we made, other than just a letter of support. There was no financial buy-in of any description.
Thank you.
That's one you owe me, Rex. Any further? Oh, sorry, Evelyn.
No, it's all good. Just looking at the bills waiting action, or whatever. We need to take positions on some of these things as a council, I believe. So, and I guess for some people it will look good, but the repeal of Good Friday and Easter Sunday as restricted trading days, particularly regarding the sale of alcohol, and given that we are looking at the full well-beings and the harm of people being on holiday for long periods of time and consuming quantities of alcohol beyond what they normally do when they're stuck at home with their significant others and children. Also, whether this is the message that we want to send as a city, that we're a city that actually doesn't give people some time off at some time during the year. We don't ask for much. 3.5 days, or 3 2.5 days, I think is what we close for. Can we not please be supportive or of opposition to this particular one? And also, it doesn't have a good deal of impact here, but could potentially, and that is the private members bill that stops Public Works taking Māori land. You might not think it matters, but it actually does. So should we have an opportunity to make a comment, could it be a comment that is supportive of protecting what remains of Māori land from the evils of the Public Works Act? Thank you.
Darren, did you have your hand up to speak, or?
I did. I was just going to move that the report is received,
Yeah,
but
so I've
in
got
doing
that.
so,
Yes.
I'd also like to echo Mr. Day's comments about the CrowdStrike outages. I had no idea it had happened until I got Michael's email of that night, and the subsequent unpacking of it over the next several days, and realisation of how quickly services that were down were reinstituted, particularly here, because they had a show to do in the Civic that night. I had no idea how close they were to not being able to perform in front of an audience. The water infrastructure, it was one of those moments when I was really proud of what our staff had done, and so I didn't want that to go without additional acknowledgement.
Yep, thank you. So you're the seconder, Leslie, and do you wish to speak to it as well?
Yes, I did have a question for Michael. So Michael, on page 177, how is the work on the recommended updates being progressed with the aim of a draft plan change to address urgent housing matters different from what was asked for in the notice of motion?
Through yourself, Mia, it's not significantly different. I guess the motion gave us some clarity in relation to the information you were requiring, but it's not that different. We are working on it. We've got some contractors we are trying to engage in relation to getting that piece of information source. It is in tow. From our perspective, we are on track to actually achieve that outcome. And I'm sure if Jonathan was here, he would reinforce that message that we are on track to get the information to you.
So the information that was asked for under the notice of motion, if it's given to us before early 2025, is just going to say we'll have a draft plan change for early 2025. Is that my understanding?
In essence, correct. One is about the information required, and the other one is about what action we're taking to actually make the amendments, intensification, and then how we're actually going, what are the district plan changes required to go through the process. So that's what the 25 one's talking about, is the actual changes.
Thank you.
All right, there being no further discussion, we've got a mover and a seconder. All those in favour?
Aye.
Carried. Anybody opposed? No. We now need to move out of public into public exclude. Does somebody like to move that? Darren, thank you. Peter, thank you. And just to signal before we go tonight, a quick. Are we off live stream? Oh, sorry, I need to put a motion. All those in favour?
Aye.
Carried. Are we off live stream yet? We are?
Gil, can you confirm we're off live stream?
So we are off. I'll give you a very, very brief update on the. I'm getting a finger waved at me by Lisa.
No, I'm pointing.